of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, did everybody get a copy of the minutes? And has everyone read the minutes carefully? Any corrections, additions? If not, somebody move to
I
accept
move
the
to accept the minutes.
as written. Okay, all those in favor? Aye. And the minutes are accepted. Announcements, I have none to make. Bill, you got any announcements?
Yes, sir, if you don't mind.
Please.
Good evening, Board. I'm Manager Bill Williams of the Code Enforcement Office. I would like to say welcome to two of the members that I don't think I've met yet here, and thank you for taking your time out this evening out of your holiday shopping. I have no doubt to attend this hearing tonight. Just a couple of quick things. I just wanted to introduce to the board any members that have not met Assistant County Attorney Heather Chrisman. She's going to be helping us present our cases here tonight. And also, we have a new officer in our office, and I would like to introduce him to you, and that is Officer Michael Lynch in the back there. We are very excited to have Michael as part of our team. He's been with us 3 months now and brings a very extensive background in law enforcement. He had a distinguished career with the West Virginia State Police. So we are excited to have him with us and just wanted to acknowledge him, and we can get started.
Okay. All those who are going to testify tonight, if everyone could rise at this time and be sworn in, we can, so if anybody's planning on talking here tonight, please stand. And would you?
I state your name.
I, William S. Williams,
Do solemnly swear that the testimony I'm about to give is the truth, the whole truth, and nothing but the truth.
solemnly swear that the testimony I'm about to give is the truth, the whole truth, and nothing but the truth.
Okay, thank you. Discuss tie votes. Who wrote that on? Anna. You did? I did. Okay. Oh, how many of us are there? 1, 2, 3, 4, 5, 6. An interesting number.
A couple of months ago, there was, you
just go right ahead.
Okay. We had a tie vote a couple of months ago concerning an issue, and we essentially said that the conclusion was that the motion didn't carry, so therefore it was essentially what turned out to be a no vote. Right. Well, after that, I read in the newspaper, and probably the lady that wrote that article,
Dottie Nist.
Yeah, about a hotel that was being built on the east end of 30A, where the County Board of Commissioners had heard about a change for some reason for that hotel, and it was a tie vote, and so the people wanting to build this hotel took it to court, and a year or so later, the judge, a Walton County judge, I don't remember exactly which one it was, said that the county commission erred when they took the tie vote as a no, that what they should have done, and they went back and did this, was to table it and then take it up at the next meeting to where there was a decision that the people bringing the issue had a right to have it decided. And perhaps that same kind of logic would be appropriate for us, and if we want to get it right, we probably need to go back and hear that case, if you agree, and if our attorney thinks that whatever this judge said, it said that the proponents are pro or con have a right to have it decided, and a tie vote's not a decision.
I'll review the case. And do you happen to know the name of the case?
It had something to do with the hotel at the other end, and it was a county.
No, the one here, the one with the code board. Which was the case?
No, it was.
No, I know. Which was the one?
It was where that fella lived at the end of a dead end, had a bunch of trash and construction materials on the lots that he had
That was where
purchased.
several of you you and Mr. Lovell had to recuse yourself, or, no, you
No.
didn't recuse yourself.
We didn't, I know the guy,
But you
the
did.
fellow, who was running a construction business, right, and there you go.
Yeah.
It seems to me that time gave the commissioners the opportunity to speak about the decision they made among themselves, which is a violation of sunshine law.
No, what it was,
Chairman, if I could,
Yeah,
clarify
please,
this particular issue, I was there for that hearing and I'm very familiar with the court case. What the judge decided was that our procedure was not proper at that meeting. There was a 2-2 tie vote on a motion to deny. The judge ruled that that motion failed, but it should have been followed up with another motion, a motion to approve. If a motion to approve had failed on a 2-2 tie, the case would have been over. It would have been denied. But because it was a motion to deny that failed on a 2-2 vote, that called for a follow-up motion.
Oh, wow.
It was an incomplete action. There was no suggestion to wait to the next meeting, or to continue the item. They should have followed up with another motion right there. That was what the judge ruled on.
If it had worked the opposite way, would they have voted, if they had initially voted to approve 2-2?
If it failed to-
Yeah, well, then they had to vote at the deny one?
It would have been a
Yeah.
it would have been,
Because it was a motion to deny,
Right.
and the board's rules are a 2-2 vote fails, it should have been followed up with a subsequent motion to complete the action.
okay, that makes sense.
That
All
was-
right, so in our case, we decided that he wasn't in violation, right?
No, we decided that we didn't approve the motion that he was in violation, so we tied it, and then said, well, he's not in,
He's not in violation.
right, so we did the right thing.
You did the right thing.
Okay, all right, thank you. Yeah, okay. All right, then I think we've worked our way to case number 173513. And Anna, you're going to present it to us?
Yes.
Wow, that's a hell of a case.
For the record, I am Officer Anna Riker, and this case 17-3513 with RCB Gorman Group LLC. Violations are outside merchandising and storage without permits, signage and building signs without permits. So, sorry, that's too fast. And this is the parcel located, sorry, hold on. Parcel is located directly on 98 within the scenic corridor. And this is prior to the building being placed on that parcel. This is the picture of the violations. First of all, the golf cart was parked out front without outside merchandising permits, which are required on scenic corridor. The monument sign does not meet the approved standards, which is in one of these packets, but anyways, it also does not have permits. The sign on the building, which is facing west, the sign on the building is facing west. It does not have permits either. And my reinspection today, they are no longer displaying the golf cart out front, but their signs still do not have permits approved. My first inspection was October 20th, and they were notified properly. Got no response. They did turn in an application for the outside merchandising, but it cannot be approved until these signs violations have been brought into compliance.
What's particularly wrong with a monument sign? They just don't have a permit?
They, first of all, don't have a permit.
Yeah. But if they had a permit, is it in compliance? Would it be in compliance?
They don't meet the requirements, and it's in a packet that I sent around, but
We don't have that.
Yeah.
You have a packet?
This is the only copy.
Oh, okay.
I can send it out.
I don't have a packet.
Neither do I.
Yeah, we should have showed a little bit.
But the process for the building signs, they have to submit, to the scenic corridor review specialist, which is, planner, Tim Brown. They also have not submitted, for review for the design review board. And then the, monument sign is unapproved with no permits, and the changeable copy exceeds the allowed space.
Okay. That's what I want.
Can I see that, Tom?
Yeah.
I would like to recommend that the address, 3525 Highway 98 West, is located within the unincorporated area and is subject to Chapter 12 of the Walton County Land Development Code. That proper notice of hearing was provided to the respondent. That violations of Walton County Land Development Code 13.03.00N, 13.03.04.07, and 13.03.04.09 exist on the property. I'd like to amend that to take off of the outside merchandise since they're no longer doing that.
That was the first number that you gave, because this,
Yes, the 13.03.00N is the outside merchandise.
okay, we don't have that one on ours anyway.
Okay. Also, I'd like to recommend that the respondent is to immediately remove the merchandise from outside view, which they have. That the respondent is to correct the violations within 60 days of the date of this order, or February 21st, 2018, by removing all unapproved monument building signs or obtain all applicable permits. The respondent is also further ordered to contact the Walton County Code Enforcement Department to arrange for a reinspection of the property to verify compliance. And if they fail to comply with the above action or fail to bring the property into compliance with all applicable codes, ordinances, and regulations according to this order, that the board assess a fine of $250 per day, $250 per day until the property is brought into compliance.
Does anyone on the board have questions for Anna? Is there someone here from the other side? RCB Gorman? Yes, would you like to speak?
Sure.
Okay. Do you have any questions for Officer Reichert before she sits down?
I do not.
Okay, would you come up here, please? Were you sworn in? Were you
Yes.
here?
Yes, sir.
Okay, would you tell us your name?
Thank you. My name is Colin Gorman, and the outside merchandising has been removed. Didn't know that you had to have a permit for that. Apologize. But the signage, as far as we hired Johnny Himes Signs to do the signage. I had no doings of signing what was going to go up. We just told him what we wanted. He said, we'll get it done. I was not involved in any of it. What I know about the marquee sign was it was approved. However, there were 4 removable letter slides in the marquee sign that he submitted, and the one he put up has 3. So it actually has less, but he put our brand logo permanent on the side. So it's the same amount of space, according to him, he just did it different. I never saw the 2 different signs, I just saw what he put up. So I don't know what was submitted and what was not. I'm being told now that a different sign was submitted for the development order than what was actually installed. The golf cart sign apparently didn't get a permit pulled. I knew nothing about that. I apologize for that. And it's my understanding that Johnny Himes has been working with Tim Brown to get it all addressed. I do have emails from Tim Brown saying that he saw no issues with the monument sign, but the golf cart sign, as far as I know, for 6 weeks now, him and Johnny have been trying to get it permitted. I believe there was a meeting on December 4th about it, and that's all I know.
What do you know about that, Ms.
I
Reichert?
just would like to note that I did allow, or would like to allow 60 days for that permit process to happen, and it should. That's reasonable time.
I mean, I was told that everything should be able to be permitted, and I apologize, I didn't know if there was any issues with any signs. I had no intention of putting up the wrong signs. I specifically designed my building where merchandise would not be on display. I don't know if any of you have ever been by there, but there are golf carts outside. But I specifically designed my building so I wouldn't have to come and do this. So I apologize. So I don't know what's gonna happen with the signs, but if you need me to make any changes to the signs, I'd be more than happy to. But that's really all I have to say.
Well, you have apparently 60 days to get yourself in order.
Okay, with Tim Brown, is that correct?
With the county, Tim Brown represents the planning department,
Okay,
but you need the permit, not Tim Brown's permission.
right, but it has
Yeah.
to start with Tim Brown, correct?
I think so.
Sign group.
Yeah, he's the guy that does the signs, right? And
Yes.
only Tim, yes.
Scenic corridor specialist.
Okay.
Who gets the permit, Mr. Brown or this gentleman?
Oh, yeah.
No, he does.
The property owner is responsible to follow through the process, and Tim Brown is the planner who will issue the permit once everything is.
I understand that, but, okay, all right. But the responsibility for the permit lays on this gentleman here.
Correct.
Good.
Is there no, Mac, maybe there's a question for you, there's no, he claims he was ignorant of the sign regulations. One would think that Mr. Himes wasn't ignorant of the regulations. How could we be certain in every case that the property owner is aware of this ordinance?
Well, in order for Mr. McCarver from the planning department, in order for Mr. Hines to represent, the property owner, he has to sign an agent affidavit. As representing the owner. Now, I don't know that ignorance of the law is a defense.
That's right.
In our country, state, and specifically our county. And he hired someone that purports to be professional, knowledgeable about, he would rely on his professional expertise. But again, the owner doesn't have to hire a consultant. The owner is responsible for being knowledgeable about our requirements that are being business.
Okay, Anna?
That's why I feel a reasonable time of 60 days, or maybe another recommendation, gives the owner enough time to educate himself and go through that process.
Okay.
So that's where I feel we want to give him reasonable time to get through that process.
I understand.
So the sign company only has obligation to him, not to the county, right?
That's right.
I mean, He's the ultimate responsible.
That's right. The permit's
Yeah,
issued to
It
him.
was my understanding that it was gonna take some time to get the signs permitted. It took me 180 days to get the permits I have.
I
So I don't
understand.
know if the 60 days will be enough time. The marquee sign that is up, that was permitted, which is technically the same amount of information on it and what was permitted, if you measure it, it's the same,
Mm,
100%. And be happy to have somebody come out and measure it.
Yeah.
Well, let's hope that you can come into compliance by that date, and if you can't, and if in good conscience, some application process is in process, hey, we'll listen, okay?
That'd be wonderful, I'd appreciate that.
Okay, any other questions for this gentleman? Is there any comment from anybody out there?
I would just like to make a comment that
Yeah.
this case and the next case being presented, for the record, Officer Reichert is submitting a final report that will be part of the permanent record, and so will Officer Rhodes, okay? I think she failed to mention that, so they're submitting a final report for the record.
Okay. All right, hearing none, yeah.
No, but I'm gonna make one. All right. I move we accept the recommendations of the code officer.
Second?
Any discussion? Hearing none, we'll vote. All those in favor?
Aye.
Any opposed? And the motion carries unanimously. So you have till February the 20th.
I'd like to make a motion to pay for the administrative cost of the
Okay, well,
hearing.
let me just tell, you got till February 21st to come into compliance, or come back and tell us why you aren't.
Fair enough.
Make a motion to pay for the administrative cost of $450.
Wait,
Nope,
I just didn't hear what you said.
He moved.
moved.
Is there a
that he pay
second to that motion?
$450 administrative.
Charge it for tonight.
Yeah.
Mr. Chairman, if I may, we've had some discussions with the
Wait a minute, let's
assistant
get this
county
either second or
attorney
not before
regarding
we.
the administrative fees.
Time out, we're out of order here. We
Well,
didn't-
wait a minute, he's addressing the question of
There
the
hadn't been a
motion that you
second to the
just
motion.
made.
Yes, regarding the administration fees.
I know, but
That's
if we don't
what
have
you're
if we don't have a second, it's
Well,
mute.
he can talk about it.
Okay.
Okay. I mean, you can say what he says, when he gets done talking, hey, we'll see if there's a
no
second.
on that motion, Tom.
Right, so at this point,
We can
You
discuss it.
discuss it after we
Yeah.
have a
No,
motion.
you-
all right, I'll second it for the purposes of discussion, okay?
Thank you.
Okay, now, Bill, tell us.
If I may, we've had discussions with the assistant county attorney about the administration fee. There are some legal questions regarding the fee amount that we are charging here. So we are, if you'd like to maybe address the chairman with what.
Good evening, Chair.
Hi.
Members, Heather Chrisman, Assistant County Attorney for the record. Yes, I had some questions about how the county has been arriving at the administrative cost of $450. There is some legal precedent that I have concern about it, and so I have recommended to code enforcement staff at this point in time, until we're able to fully review and just make sure we're asking for the appropriate cost amounts, that we not ask for any cost at this point in time.
Well, we've been charging this for,
Yeah, a few
forever.
years.
I
Yeah.
understand, and, you know, and it very well could have been that maybe it was appropriate at some point in the past, but there has been some case law and some attorney general opinions that discuss that issue, and it could very well possibly be that those were, you know, after the practice had begun. So we just want to make sure that it's shored up in line with the laws right now.
we'll have to ask our attorney, what's your opinion?
Well, this was brought to me earlier this evening. There is some case law regarding the tax collector and various other entities on having to only be able to recover hard cost for their functions. And whether it extends to this board, I haven't looked at that directly, but I'm sure Ms. Chrisman and I can look at it and we can come up with something to recommend to the board for the next meeting.
Well, just for
The county is
information,
happy to
just for information, that was gone through years ago by the attorneys at that point and the code board attorneys. And that's the number that they came up with.
I understand that, but that's fine. Yeah, but like I said, we just want to make sure that if we're imposing an amount, we just want to make sure that it's a good amount and fair to the citizens.
Seems like you lucked out.
Well, I was gonna make a motion, we table it until we get an answer, because
Oh,
this
perhaps-
could take forever.
I'll second that.
Yeah,
So I think I'd make a recommendation, we table the administrative fine until we have the solution for this and hold it
But
in
we
advance.
have a motion on the floor, Tom, you second. it.
right, and that motion was that we,
Yeah, So we need
Levy
to
the fine.
dispose of that.
Okay.
well,
We need to vote on that.
let's
motion.
vote on it. All those,
Is it still a motion? You want
Yeah,
to?
the motion's there, we gotta dismiss.
What is the motion?
The motion is that we're gonna charge him $450 administrative cost. So all those in favor, hopefully there's no one. And all those,
We could amend the motion.
Yeah, or you could withdraw it before we vote on it.
No, I could amend the motion if we have a second for that.
we'll go ahead and amend it then.
Well, I amend the motion that we table it until we have an answer on the administrative
Yeah,
decision.
I'll second that, go ahead.
Okay,
Okay, we vote on that first, and then we vote on the other one.
okay. So this is the motion to amend the motion.
Right.
All those in favor?
Aye.
All those opposed? That motion carries. Now we vote on the motion itself. That is,
I don't know the answer to that. Do you vote on the first one?
You vote on your amended motion at this time.
We did. We just
No,
passed
we-
that.
we
You
voted
on-
to
you
amend
to
it.
amend it. Now you're gonna vote
The-
on, that's what he called for, was a vote to amend
Yeah.
to allow the amendment. Now you're voting on your amended motion to table it until.
I got you. Right.
okay, so all those in favor? Again, aye. Any opposed? Okay, so you still have till February 21st. In the matter of the fine, we don't know yet. The administrative cost, not the fine. Okay.
We just spent the money.
Yeah, thank you.
Thank you for your time.
Yep, okay, so, Anna, you're ready for 16-1231?
That is Officer Rose.
Oh, okay.
Do we have any handouts for this one, Ina? No.
I'm ready if you are, Kurt. Load them up. Yep.
final report and PowerPoint presentation is evidence. This is code case 16-1231. Thad Perlitz is the owner of the property located at 8528 County Highway 38 East Inlet Beach. On March 15, 2016, a complaint was received by Walton County Code Enforcement Office concerning building a deck on the dunes without permits. The property is located in unincorporated area of Walton County. Officer Stephanie Manning at the time conducted the initial inspection on March 29th, March 29th, 2016. Then on April 13th, he issued a notice of violation. The notice of violation at the time was for Chapter 11 development order approvals and Chapter 4 resource protection permits. On May 13th, Mr. Perlitz requested more time as he was awaiting response from DEP regarding DEP's permit. On May 23rd of 2016, an update from DEP was received stating a compliance letter had been sent to Mr. Perlitz with recommendations for corrections. On July 7th, 2016, Jim Martinello at DEP stated the deck would need to be reduced by 4 feet landward and moved out of the side setbacks, which was 7.5 feet. If corrections were made, then a permit would be issued. No permit was issued at any time, and on November 1st, 2017, I conducted an inspection on the property and still had not come into compliance at that time. On November 2nd, I contacted Jim Martinello with DEP. He stated he was going to contact Mr. Perlitz that week regarding a consent permit to be issued. Mr. Martinello explained that this case had fallen kind of by the wayside in importance due to his office being retasked for storm-related permitting from the storms that affected the state in 2016 and 2017. Basically, he just said it fell by the wayside because other things are more important. Came up with a small deck. On November 8th, an updated notice of violation I sent to the property owner of record of Fulton County Tax Collector's Office, citing violations for Chapter 11, the development order approvals and building permits, Chapter 4, resource protection standards, and Chapter 5 for the building setback requirements.
Are all these on PowerPoint?
All one on PowerPoint.
The ones you're just talking about? Because we have one that, you said this was going to be on PowerPoint, so.
It is. That's what you're looking at right now.
Okay.
Bear with me.
Okay.
These are old. That's why I'm going through the timeline. On November 8th, when I sent the updated notice of violation. On November 20th, I spoke to Mr. Perlitz, the property owner. He requested more time as he was still waiting for the DEP permit. I gave him until the 28th of November to obtain his permit. I spoke to Jim Martinello on the 21st of November, and he said that was not enough time, he wouldn't be able to get it.
That's 2016.
That's 2017.
17.
Yes, a whole year went by where DEP did not issue the permit. Basically, they got recast to do other things, is what I was being told. I sent the notice of hearing to Mr. Perlitz, the property owner, for this code board hearing. On December 6th, this month, I received an email from Mr. Perlitz to let me know that a portion of the deck had been cut down and removed from the setbacks. An inspection of the property showed that was the case. It actually did get moved out of the setbacks and was cut down to size that DEP wanted. On December 11th, that was on December 11th. On December 19th, a signed consent order from DEP was sent by Jim Martinello, which authorized the property owner to have the deck on property as the way it was sitting at that moment, with the corrections already made. This satisfied the LDC Chapter 4, so there was no longer a violation there, and it also satisfied the LDC Chapter 5. Was the other one said? I'm sorry, I wrote that one down. Chapter 4 and Chapter 5. The only one still left out there was the Chapter 11, which is what is on the board for you to see. That is the only current violation on the property. He still built something without getting a permit from Walton County. Now, he must take that consent order that he received from DEP. He will have to turn it into the planning department. The planning department's going to require an as-built survey from him to show exactly where it's located on the property, in order to, and with his application for a consistency letter. Once that's granted, he can then go to the building department to get his building permit itself. Chances are they'll ask for an engineer to sign off on it because it's already built. That's a typical thing that the building department does. The planning department states that it'll take about 30 days to process the application once it's received. The building department states another 2 weeks beyond that to get their permits aligned. The as-built survey, if he orders it now, chances are will be 4 to 6 weeks out based on current estimates with surveyors. They're pretty far behind right now. So that's where it sits with where we're at for their permits. The next slide. That is a picture of the existing deck and the timeline of the complaints that are the old deck of what it looked like prior to and leading up to the new notice of violation that I had sent. Green cards were returned. The new deck, after he cut it down and cut it back, looks like that. It's actually shortened to the span that it needed, and it actually has 2 pilings less wide. Here you can see from the bottom, it's only 2 pilings wide now, before it was 3. So they considerably cut it back and cut it out of the setbacks to get it out of the way and reduce it in size that DEP requested. And this photo, by the way, was taken today when I went out there, just so we had an updated photo as what it looks like right now currently. Okay? The recommendation for enforcement and penalties. It's my recommendation that the code board determine that the address 8528 County Highway 30A in the Beach, Florida 32461 is located within the unincorporated area of Walton County and subject to Chapter 11 of the Walton County Land Development Code. 2, that proper notice of the hearing was given to the respondent. 3, that a violation of Walton County Land Development Code Section 11 does still exist on the property. The respondent is to correct the violation within 90 days of the date of this order by obtaining a building permit and a certificate of completion on that permit. The respondent is further ordered to contact the Walton County Code Enforcement Department to arrange for a reinspection of the subject property to verify compliance with this order. If the respondent fails to comply with the above actions or fails to bring the property into compliance with the applicable codes, ordinances, and regulations, according to this order, the board will assess a $250 per day fine until the property is brought into compliance after the 90 days.
I have a question.
Questions? Yeah.
Do I understand this? He built this before he asked for any permits whatsoever from anybody?
That is correct.
From the state as well as the
From
county?
the state as well, yes. From DEP as well. It was built, he just built the deck up in his backyard.
Okay.
We're talking about the builder rather than the owner.
No, that's, who built it, the owner or a contractor?
From what I understand, the owner had some friends of his build it. It wasn't like a separate licensed contractor came, it was just something that they did.
For all grins' sake, it was the owner himself.
Yeah.
Any other questions? Okay, is Mr. Perlitz here?
I do not believe so, no.
So no one's going to speak on behalf of the other side?
What can he say?
Not for Mr. Perlitz, no.
Okay, well, as I understand it, someone's concerned here. Sir, who are you?
He's a different guy.
Yes, sir. My name is Will Dunaway. I'm from the law firm Clark Partington, and I represent the adjacent property owner, Mr. Buster Bickerstaff. We are here. We let the staff attorney know and also your board attorney know that we would like to be heard on this matter, just to go through and let you get the facts of this issue and then to ask any questions that Officer Rose has, because quite frankly, my client has been involved throughout this whole process. There have been new players to the town, but we have a lot of the facts that we'd like to present to you.
Are you the one, was your client the fellow who filed the complaint?
No, sir. No, sir. We as the adjacent property owner who is impacted by this, both
Okay.
the structure that has been a violation of the side setback, as well as the erosion that this illegal structure has caused.
Okay,
And if I may,
yeah. There's no reason I should deny them permission
No,
to,
sir.
no,
It's public comment.
okay.
for your benefit, I have copies for all of you of a timeline of this, the county's efforts to try to bring Mr. Perlitz into compliance. And while that's being passed, I just want to go through a couple of things and bring you up to date on this whole process. You heard from,
You have to share.
I don't know. Do we accept this as an exhibit, or it's,
Well, are you presenting it as an exhibit or just a, for?
what I'm offering it right now is for an aid, and we'll look if you have questions as to whether I seek to offer it into evidence. It gives you a timeline of this whole process. You heard Officer Rose state that the first violation of this, the complaint was made in March 16th of 2016. The first violation was issued in April of 2016, and that was from your code enforcement officer, and it required Mr. Perlitz to fix this issue, correct it, by May the 13th of 2016. It told him that he had to remove the structure, and before he could build the structure, he had to get the permit to get a process. Anything built forward of the CCCL line, as you know, requires state permitting. But that did not prevent you, Walton County, from enforcing your own code. You can't build things in Walton County without getting the proper building permit. However, Mr. Perlitz asked the county and said, "Look, give me the time to go get that." You heard Officer Rose say that. But members of the board, it's been a long time, and we'll see the actions that Mr. Perlitz has taken, and it has been very minimal, and only recently. That first violation, that correction was required by May the 13th, and you have the documents, the notice of violation that shows that. He was supposed to bring that into compliance by removing it and applying for the permit. He did neither. He neither attempted to get the permit from the county or remove the structure.
What's that date right there?
That date is, he was required to have it corrected by May the 13th of 2016. And to help you with your calculation, that was 583 days ago. And at $250 per day, that would be $145,750 for that violation. He did not do it, and importantly, I want to, with all due respect to Officer Rose, I want to provide you with the DEP's letter, which was issued on April the 13th of 2016. That letter, and I'm going to submit it, was a notice of violation on this issue. And it said that he was in violation, and it was what it was referred to as a compliance assistance offer. And it said to Mr. Perlitz, because instead of you're not getting a permit because you were out of compliance. And the compliance report stated very, very clearly that in order for the department, this is DEP, to consider approval for a relocated wooden structure on the subject property, the proposed relocation area should be located a minimum of 15 to 20 feet landward of the deck's current position. That is, back into the yard. Obviously, the DEP was not worried about the side setback. That's the county's ordinance. The side setback, he was in violation of the side setback by approximately 4.5 to 5 feet. So the structure as it existed at that time was this structure that I have on the poster board. You saw earlier pictures. This was the structure. This is an extended deck. It is a extends the bank out over the bank, and you saw the pictures, I'll show you another, that extends it out. The DEP told him that had to be pushed back 15 to 20 feet back up here on his lawn, not out over this process. You'll see the shoreline, you saw this from Officer Rose, the shoreline angles, right? So what he was trying to do is he was trying to get himself out beyond this board fence, 6-foot board fence that Mr. Perlitz himself built along your county access, your public county access, presumably because he didn't like people walking down here and looking in his backyard. That was his decision, his choice. But that prevented him, if he had sitting out here on his own backyard, from being able to see. So instead, he decides to go out and illegally build a deck structure hanging out over the cliffs, over the dunes, illegally. And when he gets caught on the violation from your code enforcement and from DEP to rectify this, the action that he takes is nothing. Nothing. He doesn't remove the structure. He doesn't rehabilitate the dune, as he was told. He doesn't do anything. He doesn't do this for all of these months. This was made in April of 2016. On and on and on, as your as your timeline shows. We're following up, then there's over a year action, and over a year with no action. So we get back and we try to re-energize this. Why is this deck still here? Again, the county is not casting dispersions. The county was waiting for DEP. DEP wasn't doing anything. So I'm not blaming the county. The county was, look, if he gets this permit, because they do have a permitting process, if he gets it, then we can make some decisions. If he doesn't get it, it's easy. We don't have to do anything. Because if he doesn't get the permit, we've already been told by DEP he's supposed to move it. So everybody was sitting around knowing that he's got to remove the deck, which he doesn't do.
Can we get a copy of that, please?
Yes, sir. I'm going to submit that. I'll go ahead and submit it. This is the April 13, the first letter is the April 13, 2016 letter from Officer Manning, your code, and then the April 20th, 2016 letter from DEP, the Compliance Assistant letter. I offer this letter, these two letters, in the evidence.
Does the
Quick.
county have a copy?
Yeah, do we have a copy?
The county wrote it.
The county was copied on that letter.
Are there any objections?
Can we
from
see
the
it?
county?
Can I see what it is?
Quick question.
Yes, sir.
That stairway going down the dune, that's a public access
Yes, so
that
that's your public access.
the state had already approved?
Yeah, so this is your public access. That's
our
the
stuff.
public beach neighborhood access that comes down. You maintain that, and it is properly permitted.
And just in a thumbnail, what is your client's problem with the deck?
Um,
We have to get into that.
well,
Yeah.
You're about to get
Wait,
in,
wait,
okay.
well, let's worry about whether this gets introduced to evidence or not.
We don't have any objections to the county.
Okay,
Y'all accept
then we'll
it as
accept it
evidence.
as an additional Exhibit A. How about
Martinello?
that? Okay, you could go on.
Yes, sir.
Yeah,
That's
yeah.
his client.
so nothing is done for that amount of time. So then we re-energize and say, let's go. Why aren't we getting any, why isn't this not being taken care of? Why is this person who's been told he's in violation by the state and the county and told what to do with this structure, that is remove it and apply for a permit, why isn't he doing it? And so we get it re-energized, and as Officer Rose, and thank you to Officer Rose for stepping up and taking over and picking this up. He issues a second notice of violation on November the 8th of 2017. That's what you have.
Can you hold on just for a second, would you please?
Yes, sir.
Tom, we need to decide what we're going to do.
Oh, we're going to accept them into evidence. Yeah. If there's no objection from the county, I have no problem. Yeah.
So the second notice of violation, November the 8th, 2017, and it says, fix this by November the 18th of 2017. And it tells him what to do to fix it. And nothing happens. And then you heard Officer Rose say, and he says, I'm gonna need some more time to get a permit from DEP. Again, we don't know why DEP wasn't acting in this. It's dumbfounding to me. But in any event, nothing happens. I am pleading with the county attorney. Why is this not happening? It's on the code enforcement board. And so the only way we're going to get anybody to answer any questions at DEP is to subpoena the guy. And so the county, great on them, they subpoenaed James Martinello, the DEP officer who signed that letter. And good on them for doing so. Guess what? The DEP got subpoenaed, and they had to show up to Walton County, South Walton County, on the 21st of December. You know what they were able to do? They were able to get a consent order issued in a couple of days. And that's why Mr. Martinello is not here. So what you heard Officer Rose state, he said that there was issued a permit from DEP. That is not what it is. What DEP issued was a consent order. A consent order is DEP's ultimate violation of, it's how they get their violations solved. They didn't go to a warning letter. They skipped the warning letter and to the more severe consent order, which requires fines and states a violation and gives a conditional ability for a modified deck structure to be on that bluff, if properly permitted by the county. However,
What was that fine? In that,
it's $250.
in that,
No, actually, I think it's $500, to be honest. Let me make sure. Let me state that. I'm looking, and I'm going to introduce a copy of this in, and it is $500.
a day?
No, sir.
What?
It's a
Okay.
single. It's a single.
No, this is the first time through.
The consent decree is really an order by the state.
It is, it's called a consent order, yes, sir. Yes, sir. It is a consent order. And-
Not by a judge, but by the,
No, sir, it's by the, signed by the by the director of the Northwest Florida, District for DEP. I do not know why I can't see 500 words.
that's the Department of
Oh, it is
Environmental.
500. Within 30 days of the effective date of the order, respondent shall pay to the department $500 in settlement of the matters addressed in this order. But I want to make sure, and I want to,
What's the date of that?
the consent order was issued
Today.
on, signed by the deputy director, on the 19th of December.
Where's that package?
2 days ago. Now, I want to note, and I'm going to introduce this into evidence, but on page 10 of 12, once a consent order is issued, it's under section 120 of the Florida Code. But that's an entry point into the administrative process. And so an aggrieved individual has 21 days to file a petition to contest the validity of the order. And in this case, my client is going to submit the petition contesting it because, as I pointed out to you and as you see, Mr. Martinello in the spring of 2016 told him that he had to move this and that a permit no authorization would be issued unless it was 15 to 20 feet back up the hill. But in this consent order, it purports to indicate that he has permission from the state to have it in its current location. Okay? We're going to contest that.
Wait a minute, the state wrote the consent order, right?
That's correct. The same man wrote this consent order. It's signed by Neil Hamilton, who's the district director of Florida DEP.
And the consent order says that it was an illegal structure and it needs to be moved 15 feet back?
No, sir. The letter you have that's been submitted into evidence is the letter that told him what he had to do back in spring of 2016.
So what is the effect of the consent order? That's what I don't understand.
The effect of the consent order, if it is not challenged,
Yeah.
would purport to allow the modified structure that exists on the property
Okay.
to remain.
Okay.
That's why we're going to challenge it. And to say, what are you thinking? Because you've already told us 18 months ago, you told him he had to be moved in. Then he gets a subpoena to have to come to you, and the quickest way, the only way to quickly resolve this is to get a consent order to just give permission to just be done with it. And once he issued the consent order, my understanding is, please confirm with the county, is that they released him from the subpoena so he didn't have to show up here tonight. That's why Mr. Martinelli is not here, even though he was subpoenaed. But we're going to file a petition, and that very clearly states that once we do this, this is not a final order. So as we sit here today, this is not in effect. It's not in effect until either the 21 days run or at the end of any appeal. So as we sit here today, you have Mr. Perlitz, who is still in violation of your code, who is still in violation of the state requirements, and who did not even show up here today. And that's been 33 days since you told him the second time to fix this. And if you say 33 days times 250, that's another $8,250. All told, $154,000. Now, my client is not necessarily interested in him paying a whole bunch of money. My client just wants Mr. Perlitz to do what everybody else has to do. And this is not a man who doesn't know how this works. I mean, he's an architect. So he built this house, and he got a CCCL permit to build this house. And he did not put a deck structure out there on it. He didn't put that on the site plan because it didn't go through the permitting process. He just has a friend go out and build it, and it's been in violation. Every time he gets violated, he does nothing. He gets violated again, he does nothing. Let's not reward him. Let's not reward him for doing nothing. That's all. That's what my client is looking and seeking to make sure that Mr. Perlitz follows the law just like everyone else has to. I would like to offer the November the 8th, 2017 notice of violation from Officer Rose, and also the December 19th, 2017 cover letter from DEP, which has a copy of the consent order, which you can clearly see, and the compliance report. I'd offer that as Exhibit B.
Does the county have an objection?
No, sir.
Okay, then we'll accept it as B.
I need B.
Can you get those back?
Let me have A.
When you get finished.
Yeah.
And while that's coming around, I just wanted to point out, this is the situation this is the current status of this structure. Again, I want to point out the fact that this is Mr. Perlitz's backyard looking west. Okay, the sun sets here. This is Mr. Perlitz's board fence, which he constructed to obscure the public. This is your public walkway. It comes down, and just so the audience can see what I'm referring to here. And that is this is his lawn, his backyard. Now you can tell very clearly we're just lawn, backyard ends, and we start into the bluffs. And again, this is where you really, as the county, this is your bluff, right? You have code requirements to protect this, and obviously you have to have a building permit before you can go build out a structure. And look at this thing. So this is what it looks like now because he chopped off the other half. It used to be from here. This is the deck structure. You can see that's my client's fence. It's right there. right? And so he chops it off half, right? Because you have a side setback requirement, also Rose requiring him not to be in the side setback, okay? But look at this thing. This is not a walkway. This is an extension, a deck extension. And look, there's no railings. I mean, the whole thing is just replete with unsafe. Also, hiked up here, this is the erosion. This is my client's fence. This is the erosion that is occurring because once you build this viewing platform out over the bluffs, the vegetation, which holds the bluffs together, which you have an interest in preserving, it's gone, it's sand, and now you've got this erosion problem. So this is erosion problem is causing problems on my client's property, and that's what the status of it is currently. And I just want to note that in your code, in Land Development Code, in section 12.04.03, there is a sanction for failure to obtain a permit when there is vegetation removal clearing or other development which has been undertaken without the appropriate approved permit. And in this case, your code enforcement has already earlier told Mr. Perlis that he was also required to submit a restoration plan, which is what this section calls for. It says that the violator shall be required to submit to the director for approval a restoration and mitigation plan which will serve for the process of putting the restoration and bringing this back into compliance. Mr. Perlis has not done any of that either. I'm here to answer any of your questions that you may have. I want to introduce my client, Mr. Bickerstaff, who wants to just address you very briefly to tell you and answer any questions you may have for him.
Good evening, gentlemen. I'm a next door neighbor, and these places are going along.
Mr.
all
Bickerstaff,
along.
could you please state your name for the record?
Oh, yes, ma'am, excuse me,
Thank
please.
you.
Buster Bickerstaff. I live down 8538 resident. And this violation was brought to my attention by Mr. Bull. I didn't find it. But people on the beach rejected the way it looks. It looks pretty bad. And so somebody in the subdivision told him how to contact me, and he did. So I came down and looked. My family was there, but I was out of downtown. When I came down and looked, I called, of course, and code enforcement, of course, stepped in all the issues of then a state issue one. And my big complaint about the whole thing is, I want him just to go by the rules I went by. I don't think there's anything that allows him to perch. If it is, he'll have only one on 38. And when he builds this perch, prior to this getting to the legal situation, he was always talking to me, why can't he have what I have? Well, my promontory sticks 15 feet out further than his northeast corner, which is the furthest he goes towards the Gulf. 30 feet down the west side. So he goes and builds a deck, which he knows is illegal because he's an architect, he did his house. He had to follow all the codes. He got a merit going to Jacksonville. He has to have all the code for that. And so he knew exactly what he was doing, so he stuck behind a big bush out there. Well, it was hard to see there, but it went from the beach. And we tried to get him to do something, but it really, here's my complaint is, doing this, he takes what I bought. If you're blessed enough to buy on the beach, you buy for view and you buy for location. And I got them both with my lot I bought in 2000. And he's taken my view. The first elevated deck was 18 inches from us, 18 inches from our fence. It was eye level on me when I sat down on mine. Nobody goes to the beach to watch the sun come up. You won't find one person down unless he's left on the last night. But in the evening, everybody must sit on the deck and watch it set. And he's prohibited us from doing that when he caused his own problem by building a fence. If he didn't have a fence, you can see from the pictures you've seen, he can sit in the middle of his front yard at 20 feet back and see all he wants to see. And he's doing something at somebody else's expense, and that's me. That's normally the wrong thing to do. And I'm asking that the code violations as issued be enforced. Now, the county is issued properly, the code is right, and the state. If there any questions, you know, and I.
Anybody have any questions?
He knew what he was buying now, because nothing's changed on my life. And he bought what he bought. There are no mitigating circumstances allowed him to ask any variance. And that's why he didn't get a permit to begin with, because he knew he couldn't get approved in the county. Any questions?
I don't believe there are, but thank you for your
Yes, sir.
statement.
Thank
Yeah.
I've got one for our officer.
Yeah, wait, let him, I got some too.
Okay.
What were you gonna say at this point?
I was just gonna say, just in conclusion, what we wanna make sure is that Mr. Perlett's not to be given any more time. That he's had all the time in the world. Hold him in violation today, fine him, and tell him, the main thing is, have him, as a condition of compliance, remove the structure. Remove it. And if he goes through the permitting process, he can start that over, and he can move, but he has to remove it. That's what we're asking. And we're
Okay.
here for any question you have.
Thank you. Now, Bill, why are you unwilling to do what he's saying?
We are not unwilling to do what he's asking, Mr. Chairman. The issue becomes, earlier on, we had an officer in our department who issued the initial letter.
Yeah.
That officer is no longer part of our department. There was some question in some other cases as to that officer's intentions and the way things were investigated through that officer. So what we did was we tasked Officer Rose with essentially starting over on the case to make sure that we had fairness for all parties involved. We unfortunately cannot act on a time frame of what the Department of Environmental Protection does. Our code tells us that a person builds something, obviously they have to get a building permit. We don't have an issue with that, but our code also states that if they're permitted to get permits from DEP for something, we can't rush DEP on that. So we sat back and erred on the side of caution as a way to try to be fair and reasonable in the time frame. Does it look terrible that it dragged out 1.5 years? Certainly it does. We're only advised by the state statute to give a violator reasonable time. If that takes 1 year because of DEP, is that reasonable? We try to err on the side of caution and before we bring somebody before you, ultimately anyway, if the structure needs to be removed, it's going to be something that the county's going to have to determine, and that's going to be a legal step further. We don't go out there and demolish structures that are built. Not my department, it's
But
legally done.
if he can't get a building permit, and one would think he couldn't get a building permit because he's in the wrong place, then will he be required to take the structure down?
He ultimately would be. There is an abatement process in place in this county. I've only been here a short time. I don't believe in my time here I've ever seen this county abate anything.
Have you talked to the building department about their opinion if they could get a permit?
I have not. I think Officer Rose spoke with the building.
Well, let me add to that too, if I can, before you speak. It appears to me that this deck is forward of the Walton County dune protection line, which I think is 50 feet leeward, if I'm not mistaken, of the primary dune. Am I correct? If anybody knows that's be true? Mac, do you know that? Isn't there a line that Walton County says that?
Depends on the nature of this particular shoreline, and I'm not familiar with that.
No, the properties I've been involved with, there's a Walton County setback line from the primary dune, and obviously this is way short of that, south of that. The reason I asked is if that's the case, then this structure is way beyond what the county could ever permit. So you have an opinion about that? You started to speak earlier.
No, just in regards to the building department, when I spoke to the building department will not determine one way or another where it can be located on a property. That would be the planning department with their consistency letter. The only thing the building department will be concerned with, obviously, is going to be the structure itself to make sure that it meets the Florida building.
Yeah, you're correct. I guess the planning and zoning would make that decision,
Yeah,
right?
planning and zoning, and again, he couldn't bring that to the planning and zoning until he got the consistency letter from DEP. It's the process that has to be followed in order to have all the information when it comes to planning and zoning. And again, that's why I stated earlier when he has that, his next step is going to be to get that as-built survey to show where it is, so that planning can determine whether or not it could be allowed, not be allowed, how far into the line it is, how far back it is. I mean, without knowing that, and without, I mean, you're just guessing at that point. I'm not a surveyor. That's what their job is to do, is to get that information, and that's why that process is in place.
But part of the process of getting a building permit, which we're after him to do, is that he needs to get through planning. Is that correct?
Building will not issue a permit unless it has planning approval.
Okay.
Are you waiting for anything from DEP now?
Negative. At this moment in time, the consent order is enough to comply that he would be allowed to move forward and get an application for his consistency letter with the planning department. The only thing he would be missing at that point, like I said, would be the as-built survey to know where it's located.
And that,
When are you issuing or submitting your objection to the consent letter?
We have 21 days to do so. We're going to be doing so next week, right after Christmas. We're not going to wait for 21 days. I've already alerted the deputy director of the Northwest District of DEP. I was on the phone with him this afternoon. I had, in your timeline, I told Mr. Martinelli in 2 letters back in 2016 that we would object and challenge any issuance that didn't go through the full CCCL permitting process, which, as you know, would require a survey so that Matt can make a real decision. What's planning going to do? He's in your application. You've got some notes that he drew down. There's no survey. If you were to go through the full CCCL permitting process, you'd have full engineering plans, full survey, and you'd have some process.
Well, we understand that. Can I ask our attorneys, please?
Yes.
Can you tell me where did it go? This first sentence in that paragraph, could you tell me your opinion about that, please?
Are you going to ask another question?
I think he did. He covered it.
Okay.
This is, he's asked me to read a letter from the Department of Environmental Protection dated December 19th, 2017 to Mr. Stephen Thad Perlitz. And the language you're asking me to look at says the consent order dated December 19th, 2017 is now legally binding. Attached is a copy of the fully executed consent order. Also included are the department's compliance assistance offer dated April 20th, 2016, Exhibit A. Is that what you?
Yes, and this is what you're filing an objection to.
Yes, sir, and if you look on page, I believe, Ms. Jewell, it's on page 10 of 12. It provides the statutory entry point for a challenge, and it states very clearly that if it is challenged, the matter is not final until fully resolved. But I'll let Mr.
Okay, that's what I wanted to know.
Yes.
Okay, thank you.
Okay, any more questions? If not, we could.
On the consent order, it only has to do with the state. It doesn't, they still have to comply with county,
Sure.
even though you have approval from them. Okay.
Okay, I've got another question.
Yeah.
When would you consider Mr. Perlitz to have be out of compliance?
As far as the timeline from now, or?
As far as what we should consider if we were going to fine him tonight, say, when should we?
What you asked for? How long for him to come into
Could you
compliance?
come up to the mic, please?
Yeah. Was it 60 days that you said?
Yeah, I asked
To
for
get a
90.
permit, 90 days to
I
get,
asked for an additional 90 days.
for him to get a building permit?
Yeah.
Okay.
Ultimately, there's no question that he's in violation, and he's been in violation for a long time. That's no question, regardless of what's brought forward, that is what it is. Our goal is voluntary compliance.
Right.
The county does not want to go after, pull something out of a dune and cause more damage to the dune than is necessary. In the DEP letter, it is also stated in there an extensive restoration plan. The restoration plan even calls for monitoring for an 80% vegetation coverage over the course of a year, and if it's not made, that's going to be prepared. It's very extensive. Yes, going through the planning process would also require, would be required a restoration plan and the same thing. More than likely, they would mirror each other at this point because that's what it was going to be. But again, until he had that DEP approval, he cannot apply for county approval. So at this point, he has it. To get voluntary compliance, My suggestion was 90 days. I want him to get his survey. I want him to show me exactly where it is. I want him to apply for his consistency letter. I want him to take that. I want him to go to the building department. I want him to find out from the building department, can the structure exist the way it is? Does it need railing? Does it need, what does it need? They will cover all that. That's what they do. It's my effort is to give him the time to go through that process, but not an unlimited amount of time like we had before.
And you reasonably expect that everything you want can be done in 90 days?
If not, if it's not done in 90 days, then in 90 days we'll be back here with an explanation as to why it's not. Because that's on us at that point.
Well, my question really is, can he get this all through the county? If he starts on the 1st of January, is he gonna have it all done in 90 days, all the processes you're talking about?
From everyone that I spoke to at the county, if he can have that survey in hand, yes, he should be able to get it done.
You say if he has the survey in hand?
That's gonna be the clincher there, that's why I said 90 days, because the survey is the longest one out, because right now with current market, it's 4 to 6 weeks to get an ad-hoc survey. It is what it is.
Is this guy sending back the green cards on his?
Yes, he signed everything, and in fact, when I went and met him out at his property to, when he told me about that, he had reduced the size of the deck to take photos of it. He actually had mentioned he had not been home, he wanted a copy of it, he had heard that it was coming. I gave him a copy of the notice of hearing at that time. I did an affidavit of hand delivery at that point so that he had it in hand. His concern was trying to get that DE3 permit as quickly as he possibly could so that he can move on with the process. He understood what he had to do and what he needs to do. I'm not sure why he's not here tonight. I couldn't even guess to imagine, but ultimately, for me, for voluntary compliance, the additional 90 days should be sufficient time for him to go through the process through the county and get it. If for some reason, something along the line hangs up that it's going to take longer for whatever reason, and it's on the county side of it, I will be back here in 90 days to let you know why. I don't foresee it. I've tried to account for everything I can think of in this case. That's where the 90 days came from.
Mr. Chairman, could I address the 90-day issue?
Okay, but be quick about it.
Yes, sir, I will. The reason it's not gonna be done in 90 days is because when we file for the petition next week, it's gonna be assigned to an administrative law judge out of Tallahassee. Administrative law judge is going to require a response from Mr. Perlitz. That he has a statutory amount of time to reply. Then we're going to have an initial hearing. The judge is then going to set a case management conference, ultimately leading to a final hearing once we do the discovery. And you can consult with Ms. Ewell. 90 days is not going to be that. We're not going to get through that process. In the meantime, you're going to have a structure, which is your code enforcement officer has clearly stated, is a violation of your code, and it still remains. The man still has the building which is illegal existing. Tell him to remove it now, then go through the building process. That's what everybody else does. They don't build things first, then do nothing for 2 years, and then have a code enforcement board to then give them 90 more days. Don't do that. Tell them to remove it, and then go through the process, and then we'll go through it, and it will just like everybody else does.
Okay, any other comments out there? If not, let's close the public part of this hearing, and I'll entertain a motion or discussion. Here, the public part is closed.
I'll start it out by, I move that we direct him to remove it pending the necessary orders that he has to get the building permits and whatnot.
Pending?
Well, he removes it and he go gets the permits and then they can rebuild.
So you wanted to, the motion is to remove it immediately?
Right.
Is there a second to that motion?
I'll second that for discussion purposes, yeah.
All right, look,
Excuse me, go ahead.
no, you go ahead.
How much damage you gonna do tearing, I mean, I think you ought to comply, but how much damage you gonna do tearing it out of there now? And how much oversight's gonna be done tearing it out? I mean, I don't know what to do about it, but the thing is, you can do, like the gentleman mentioned, you can do more damage right now. than anything
DEP's
else.
already told him to take it down and do a
Well, I know,
restoration.
now they're telling him he can, all he gotta do is go get a permit. So that's not there to show.
Yeah, but he
us
isn't gonna
the
be
size.
able to get a permit,
Huh?
he won't be
He
able
won't be
to,
able to get a permit, no.
right? So sooner or later, he's gonna have to take the thing down.
And sooner or later, DEP's gonna come after him for
Yeah.
the damage.
Well, the amendment to your motion probably should have said to tear it down and comply with the DEP original compliance of restoring the dune is probably what your
Yeah.
original motion
And
said.
our,
All right, wait a minute.
Is there
Our,
some legal requirement why we have to give him a period of time?
Not necessarily, you are here, he's got an order from DEP, a consent order, which, is not technically a final order. It is a standing order, but it's not final until the 21 days expires. Right now, you are in that kind of gray area because Mr. Dunaway has said they are going to file an objection to it. You as a board have the right, they have not met the Walton County permitting
Right.
requirements. He didn't meet the setback requirements either forward or to the side, as I think the testimony was it was 18 inches from Mr. Bickershaft's property line.
Initially, yeah.
So basically, yes, you could, if it's in your decision to do so, you can. And Mr. Perlitz is not here tonight to offer his objections or his comments.
Meaning we can say for him to take it down.
Well, I believe you can. I mean, I don't know of anything that would prevent you from doing so because you have an original order that said to do so.
The only thing that concerns me is we're in disagreement with the state process. And if that's the case, who takes precedence?
Well,
I think that's what the guy's doing. I think he's playing one board against the other.
Well,
all
he
the
clearly
way.
is, but hey, we gotta be, we gotta
Well,
play it
they
straight.
can't override the county. I mean, they can't
We
do
can
that.
each do our own thing, I think.
Well, but if there's a conflict, doesn't the state prevail?
Well,
No, they
the
do.
No.
the issue
We don't know
would
they'll
be,
complain.
it would be up to him to appeal your decision tonight.
Okay.
It would be,
Do our thing.
would be what I would say. I can't direct you how to, you know.
Well,
how
we
to
know
make
that,
up your
but
mind.
we-
Yeah.
their opinion. So you want to clarify your motion? And do you want to amend that motion? I'm not sure how the best way to
Well,
do that.
what was it that you think he needs to
The
have?
motion is to give him direction to immediately take down the structure and restore the dune.
And then go, if he wants to, go through the process of permitting.
Exactly, he can do whatever he wants after he complies.
And I'll second that amendment.
Is it-
So the motion is that he be directed to take
Immediate.
down the structure and restore the dune.
Immediate.
Then restore.
Immediately.
Well,
I guess-
we gotta give him some period of time. I
He
mean, you
can't just do it when they
today.
tear it off.
Yeah,
We're not gonna give him 90 days. or
right, so give him 30 days.
Yeah, you gotta give a quantitative number.
Yeah.
Who's gonna oversee the tearing out, is what I'm getting at. I mean, he can tear
They gotta go back and inspect when he gets
up.
done.
Okay.
But can we specify that he needs to comply with the restoration
Yeah,
order of the,
Absolutely.
That's the reason I wanted that added.
yeah.
You don't have to ask that question. You just
Well,
amend.
tell us, code enforcement, can we tell him to restore the dune?
Yeah.
No.
No, you can't
You
ask him
can't.
that
Pardon
question. You can't
No,
ask
sir,
him
you
that.
cannot.
Oh,
It's in the,
it's in the county.
It's a code violation, isn't it?
No, it's in the ordinance for the county.
Yeah, it's in the code.
We basically just did that. When you said to restore the dune, it means you restore it per the requirements of the Walton
Yeah,
County
exactly.
Land Development Code.
I don't have the language, somebody can write the letter.
Well, I'm sure you can make him restore what they're doing. I mean, that should be a.
Ms. Yule, is that,
Well, I'm looking at chapter 12 of the Walton County Land Development Code, .04.03. It says, basically, after the fact, permit, the violator shall be required to obtain approval of an after fact, or he can be told to take it down. What you're getting into conflict with is with the Dune Restoration Act
Right.
is you've got to make sure he's doing so in compliance with that particular order as well.
which is what? What's the name of that?
The Dune compliance, I'm not sure of the correct.
Can we just
word,
use,
but,
can we use that nomenclature?
yes, sir.
Dune compliance, restoration?
Dune Restoration
Appropriate
Compliance
dune
Act.
compliance.
Dune
Dune
restoration compliance.
Restoration Compliance Act, is that not right?
I thought we should say.
And do we get in trouble with the turtles? Is this turtle conflict?
John, I mean,
I
we
think,
gotta end this thing somewhere, guys.
I really believe,
Fire us?
I think 30 days is way too much. We should order this immediately.
No, it's gonna take longer than that to do the dune restoration, because you're gonna have to get somebody that knows how to do that, to do it.
All right, so
Okay,
let's split up, let's give him 30 days to take down the structure and 60 days to restore the dune.
An
Well, just make
additional
it all
30
one thing.
days.
Make it all,
Yeah,
Yeah.
yeah, that's fair.
Yeah.
okay, you wanna restate it?
All right, so the motion is that we direct him to
remove the structure.
Remove the structure within 30 days and restore the dune in compliance with county
Dune
ordinance
restoration
within
compliance.
60 days.
60 days, all right.
Okay, who seconded?
I'll second.
Okay.
Well, that's an amended motion, so I'll second the amendment.
And
All right.
and gentlemen, it's coastal dune restoration environmental assessment.
I'm sure Jennifer will get it right.
Can you make sure that you get that right in the order? Okay.
Yes, and it's part of the National Environmental Policy Act.
Is that a,
Okay, so
US code or?
No, it
All right,
reflects.
so we have not yet voted on any motion, but the motion that's on the floor is that to amend the motion. Is that correct?
No, we agreed to.
We agreed to
amend
amend my
it.
motion.
Right.
All right, so we can just vote the
Can you
motion.
restate the motion, because I think Ms.
She's probably
Ms.
confused
Sigler's
like I
probably
am.
confused by the.
Yeah.
You want to read it to me, or you want me to give it to you?
You,
Tell me, I'm just gonna look in here and.
The motion is that he be directed to remove the structure within 30 days and restore the dune within an additional 30 days for a total of 60 days to get all the work done.
Well, you need to refer to this. Once
Yeah,
again,
you
it's
can
the
get-
coastal,
you can
it's-
get
The dune in compliance with all laws.
Yeah, whatever the numbers are.
okay.
Who's writing the letter?
Chief.
With dune in compliance, you restore the dune in compliance with all applicable laws.
yeah, that sounds great.
Did the penalty start at that time?
All right.
or do
We hadn't got to
So,
that yet.
Gordon, you gonna second that? Okay.
Yeah,
No, I second it.
he seconded.
Okay, well,
It's the
all
same,
right.
it's the same.
If the
motion.
motion's,
Do you want to attach a fund to that motion?
Exactly.
We will. Let's
Well-
get to that after this.
we'll do it as a separate motion, I guess.
Okay, good.
All right, so the motion's there. I think by now we all know what it says. All those in favor, aye?
Aye.
Any opposed? So the motion carries. Now the matter of fine.
I'm for it, yeah.
I'm on for a fine too.
You wanna,
I don't know when it would start, that's where.
when he doesn't come into
Start within
compliance?
90 days,
No, when he doesn't,
60.
60
the
days.
first- yeah.
60 days.
Well, 30 days for the deck,
Right.
and then additional 30 days for the dune restoration.
Yeah, can we double the fine or how do we do that?
Well,
No.
I'll just make a motion that he be charged $250 a day after the 30-day period of removing the structure.
What if he
Would we
removes
do
the
another?
structure and doesn't restore the dunes?
That's another motion.
Oh, okay, all right. So
You
the
second-
first one's pretty
second
simple.
fine.
It's just the building's got to go in 30 days, or the fine of $250 a day will begin, correct?
Second that.
Right.
And
For the structure.
you second it? Okay. So all those in favor? Aye.
Aye.
Any opposed? That motion carries.
Okay, I'll make a motion that
Now,
he find an additional 200, well, we can't make it more than that.
we can, for the dune restoration.
Now, that's,
Well, I make a motion that he find, no?
I don't know.
Contingent upon his removal of the deck. If he
Is-
fails to come
There you
to
go.
restore the dunes, then he will be fined $250 a day after that 30 days.
After that 60 days.
60 days.
So after 61 days, if he didn't take down the deck and he didn't restore the dune, is his fine $250 a day or $500 a day? And is that legal? Can we
Well,
do
you
that?
have, you have two different
Two different
violations.
Yeah.
$250 for the
Two different
days.
violations.
That's legal, $250 for each one.
Is that legal?
It's- I believe it's-
Well, it's two motions.
It's up to them to,
Yeah.
yeah.
Got a comment?
Well, if you have a question on.
Okay,
Yeah,
look,
three motions.
there's a maximum fine that we can levy,
Yeah.
and I think it's $250 a day. And repeat violators get some additional amount. But in this case, if he violates both the motions that we just made, right? One for not taking down the deck, and two for not restoring the dune, then is he liable for a $500 a day fine beginning on the 61st day if he doesn't come into compliance? Right, 250 plus 250, $500 a day.
Two different violations.
But the second violation for the dune compliance, I think he was cited, what was it?
Do we have a complaint on the
Yeah.
dune restoration?
Yeah, we still only have one original violation, so.
That's, the building permit is the section of the code the respondent has been cited under. So
That's
that's the
what makes
county's position is that is the outstanding violation is just as it relates to not having a building permit. One way to come into compliance would be to remove the structure
Wait a minute,
or to obtain a building permit.
When
The
the,
county's position is however the respondent chooses to go about,
when and if when and if the thing is removed, then another complaint can be made about the restoration of the dune.
That is absolutely correct. The county, there is a code provision in the land development code, and thank you, Mr. Duncan, for bringing that to my attention. There is a code provision that requires a restoration plan in the event that somebody did an activity that was something that is not permittable and then had to go reverse. So if the respondent does not go through that process, it's appropriate for him to go through that process. If he does not, he could then be cited for failure to go through.
Well, then my second motion is mute. We just have to wait to find out.
Yeah, we just gotta find out. All right.
So
we
when he
can-
built the thing, should there have been some dune restoration that didn't take place, which yielded those pictures that we saw of the
It
fence?
is quite possible, but at this point, I don't think we're.
We don't need
Yeah,
to
he
go
would
back on
have
that.
never got the permit. in the
All
first
right,
place.
so that's all we
So
need
we're
to do
done.
then.
We're
Well,
done.
your second motion is still on the floor. Do you want to both withdraw that?
Yeah, can
Your
you,
motion and your second?
Yeah, I'll make a motion, I'll withdraw it. yeah.
all right.
And if I may just also mention as well, with a potential appeal of DEP consent order, if it ends up that consent order gets overturned, then we would also have another complaint as it relates to the section 5 that the respondent was originally cited for. So that's kind of in limbo right now since the consent order was issued, but that could very well change.
Gotcha. Okay. All right. So are we done with this matter?
Well, I'd just like for the county to make sure that at the next meeting, to try to bring us up to date on where we are. Okay, I'm assuming that will happen. Okay.
Okay, look, I'm gonna go right on to the next case because we've got 5 of them to get through and a lot of people are patiently waiting, so
Thank you.
thank you. Okay, this one's 173011. And Ms. Reich, no. Is it you, Bill?
Yes, it's just requesting an extension on the board's order from August for the May 18th code board that we made a ruling on. Good evening, gentlemen. Bill Williams, Manager, Code Enforcement. This is case 173011, the County versus Southern Hybrid Homes LLC. This case was brought before you at the May 18th, 2017 Code Board. It was for violations of Chapter 11 authorization required prior to development and a sign permit. It was off of J.D. Miller Road. The board had a continuance in that particular case. It was continued back to the June Code Board. At that time, we did not establish a quorum. That case was then pushed back to the July 21st, 2017 Code Board. However, there was an error in the notification to the respondent, so we struck it from the Code Board at that time. It was brought back to the August 17th, 2017 Code Board, in which you found the violator in violation of both Chapter 11, 000 and 001, the required development permit, and also a sign violation. As of this date, the property is not come into compliance. However, conversation with the Director of Planning, Matt Carpenter, the violator in this case, even through the process that we were investigating this case, was working with planning to obtain the development order. Mr. Carpenter would like to address you as the board to request an extension. The board gave the individual 30 days to remove the sign and obtain a development order. However, due to the complexities of the process of obtaining a development order, Mr. Carpenter would like to ask on behalf of the individual and the planning department an extension to the board's order for compliance date.
And can you answer the question, is the sign still there?
The sign is still there, yes, sir.
Okay.
It has been covered up, and another sign has been put over it that says coming soon.
Gotcha. Okay.
Is that in compliance?
It is not.
Okay. Thank
And
you.
and this has been going on since August?
No
May.
longer than that.
No, but I mean, since we talked about
Let's
it.
hear from Mike.
Yes, sir.
Okay, Mac, you want to talk to us?
Matt Carpenter, Planning Department. In this particular case, I did direct him to cover the sign, so it would not be advertising anything while he goes through the development process. And when we, as you will recall, there was a big reluctance this in the very beginning until this board, decided to get serious about this particular violation. The property owner, immediately engaged an engineer, and has been moving through the development process in good faith since that time. There have been no additional activities, unpermitted on the site. The sign is still there, the structure is there, it's not advertising anything, and he covered it at my direction, when we first started this process. So I feel inclined to not represent him at this board, but just to make the board aware of what I directed him to do. And at this time, he's moving in good faith towards getting a development order for the use on the particular property that he wants to do. It is scheduled for the January 11th Planning Commission. It will go to the Board of County Commissioners the first week, or the first meeting in February. And it's in the condition that we expect it would be approved. And I would ask that you give the applicant some additional time to complete the development order process, which he is fully cooperating and planning on, and not have him take the sign structure down until he completes the process. He's applied for a permit. We can't grant the permit yet until the development order is approved, which would authorize the permit to be signed. At the present time, there's cooperation from the applicant. I'm not representing the property owner at this time, but I felt it necessary to at least bring my direction to him for your attention, and indicate that he is fully cooperating with my permit.
Okay,
How
thank you.
much time, Matt?
As they suggested, I think we'll be through well before this extension, but it has to go to two boards, and we don't know exactly.
What was that sought after extension, 90 days?
I think that was what happened. By that time.
17 August.
You said 90 days?
I think that would be accurate.
No, 90 days from now.
No, this is 17 August is when we ruled on this.
Yeah, I know. Okay. Does anybody have any other questions of Mr. Carpenter? Mr. Williams?
Yes, sir.
Does anybody have any questions of Mr. Williams? If not,
Is somebody here to speak?
oh,
Sorry, Tom.
yeah.
I've not been sworn in yet.
Would you be sworn in, please?
I state your name.
I, Curtis Smith.
Do solemnly swear that you will tell the truth and the whole truth in this matter.
Yes,
Mr. Smith?
sir.
Yeah, we meet again, yeah.
Curtis Smith, Knowledge Civil Engineers. I'm here just acting as the agent. I'm the agent for the applicant in the development order and all matters related to the development order. We did start that process back in August. I wasn't aware of any of this going on before then, because you just approached me to help with that. Hit a couple of roadblocks with the actual land use, a very complicated land use of Town Center 1, so it's pushed it into a major development order. He's now probably over $10,000 in permitting and engineering and surveying, environmental fees to go through this process for basically what's already built. So he is both financially and emotionally totally invested in getting this process through and getting it through as fast as the planning department will allow us to.
Okay,
Thank you.
thank you. All right, I'll close the public part. Discussion?
Yeah, what do we do about the $250 a day from the August 17th meeting where
Did we say to him that he needed to go
if
through
not
the
in running
process?
compliance after 7 days of signing the order, a respondent shall be ordered to pay $250 a day? I'm trying to find out if that has the development order or that's the,
Yeah, but Mr. Smith just said he engaged him in August of that year.
It's in this case number 3 on the minutes that we just approved today.
I don't have a copy.
okay, I just want to make sure we didn't have a problem there, so.
Well, I'm inclined, does somebody want to make a motion
I
then?
make a motion, give him the 90 days.
Yeah. Second.
All right, any discussion? If not, we'll vote. All those in favor, aye.
Aye.
And any opposed? It carries unanimously. All right, we're still moving. can we all tolerate one more? Number 162568.
Yes, sir. This also is going to be a request for reduction in fines from the board. This case was a case of Mattress Firm. They were brought before the board on May 18, 2017 for a violation of an unpermitted sign. They were given a compliance date of July 19th, and they did come into compliance. I believe you're Ms. Hale?
Yes, and it's Mattress Now.
Mattress Now, I'm
Yes.
sorry, please forgive me.
No problem.
She has so far to date, she brought the property into compliance on July 19th, 2017. So as of that date, she has accrued $3,550 in fines. And she is here to request of the board a reduction in those fines.
Succinctly tell me one more time the dates involved.
I'm sorry.
Yeah.
The code enforcement board was on May 18th,
Okay.
2017. And she was brought into compliance on July 19th. She was given 30 days, so she was just outside of that 30-day window, which she came into compliance. We signed an affidavit of compliance on July 19th of 2000.
So she was a month late.
Yes, she was approximately 30 days after.
Okay.
And what was the amount?
$3,550.
Okay, Ms. Hale, you want to talk to us?
Yes.
I've been sworn in.
State your name, please.
Karen Hale. I'm the property owner and I also own and operate Mattress Now. I wasn't clear when the fine day, what was the first day of fine?
It would have been the day of the code board, which was May 18th, 2017.
May 18th.
We gave her 30 days from that date, or that?
Yes.
So June 18th would have been the
Would have been
first
30
date that
days,
she would have
yes.
been fined.
Okay. Quite frankly, I would like the fine removed altogether. Within 1 mile radius of my building, my store, there are multiple business locations that are not in compliance and have never been in compliance.
That's not,
Yeah, that's
not
a very identifiable for all of us. We all get it, okay? But we cannot consider that. It's the case, your case that's in front of us,
Would
okay?
you consider me treating me fairly? Like
Yeah, and I tell you, if you see violations around you, you call up the code enforcement officer and report them. But at this time, that's not applicable. We're talking about your case.
About my case,
Okay.
okay.
But look, you go tomorrow, or Monday, call them up. You know, if you've got a violation that bothers you, that you have the right to do that.
Thank you, sir. I appreciate that information. One thing I'm confused about is, there was a multiple email chain on, I had a deviation hearing on July 6th. The deviation was denied. That was to have an increased size of the actual signboards on the sign, and also to have a second tenant on the sign. Once that was denied, I immediately emailed Tim Brown the following afternoon and said, Tim, please tell me exactly what to do. I want to be in compliance. I'm struggling. I want to pay as little fine as possible, so I want to fix the sign. Once I found out I wasn't going to be approved in deviation, I went to fix it. On 7/8, I sent a picture of the sign that had changed. Tim, there were 11 emails back and forth. We changed the sign 7 times within a 3-day period. The final email from Tim Brown on July 10th was, those dimensions that you told me would be in compliance. I said, can you please send Ms. Reichert out to inspect? I know I'm on a $100 daily fine. On 7/18, I had heard nothing back. 7 emails went back and forth between Tim and I on July 18th. For Anna to go out, if Tim would please ask Anna to go out and inspect my sign. On 7/19, they state that I'm in compliance. I guess in any business, not everything happens when everybody wants it to, so I understand the delay in time. Is there any leniency you can give me in the fine?
Okay. Questions for Ms. Hale, anybody?
What were you doing between May 18th and June 19th about the sign?
I never clearly understood what was wrong with my sign. Tim Brown is a nice man, but he's not a great communicator. I went back and forth and tried to understand what was wrong. I finally got on the phone with Miss Riker, and she explained to me that the sign needed permitting. I had already been to a sit-down with Tim, and I quote Anna in the statement. She said, well, I said, well, Tim, I didn't understand that from Tim. And she stated, well, you have to pull information out of him. And I think in that position, you need a damn good communicator, because we're businesses working in your county, and we're trying to do the right thing. And when you assess a $100 fine on a small business like mine, that's devastating. And you need to clearly communicate what is wrong with the sign. I thought for 3 weeks I was fine because my sign was green. Once I finally got a clear picture of what was wrong, that I needed an application for a permit, I did it as fast as it could humanly be done. Then, once I found out that I couldn't, with neighboring signs having multiple tenants and being large, I thought I stood a chance at the deviation hearing. When I got shut down on that, I immediately fixed the sign. And considering that I am the only sign, one of the few signs in compliance in a 1-mile radius, I don't think I should have a fine. Much less the admin fee, which has been brought to light.
No, you luck up. Well, you may luck up. Okay.
Let's hear from that.
Okay, anything else? Anna, do you want to say anything?
Officer Reichert, for the record, I just want to say that from December 2016, she had been notified, and it was a full 6 months before she took any action to begin that process of permitting.
So she was informed 6 months before all this that she was not in compliance with the sign ordinance, and was she told she needed a permit at that point?
Ms. Hill, do you remember any of that?
I know that Ms. Riker visited my store, left paperwork with my employee Don Davis. I don't clearly remember that there was a request for a permit on that. I think it's a standard form, isn't it? Doesn't it just state that we're out of compliance? Or does it actually state you need a signed permit?
Let's stop this. Yeah, no, I like it.
I'd have to go and get the actual file folder. Best of my recollection, I did a verbal information and then followed it up with a notice of violation.
And the violation would have stated the permit?
Yes.
Right.
Was this a proactive
Yes.
enforcement? Proactive enforcement?
Okay. Well, I'm going to close the public part of the hearing and we'll discuss it. Thank you. Okay.
I have one more question, sir. Am I charged the administration fee?
No, that's tabled for now.
Oh, that's the okay.
For now, anyway, yeah.
That's not part of the 3,500?
No.
Okay, thank you, sir.
Okay, anybody got any insights?
Well, I think, personally, I don't like to penalize anybody for trying to do the right thing, and if they say she's doing the right thing, I would suggest $500.
I'll go with Gordon, I agree with that.
Anybody else?
Say that again.
Well, the 6 months bothers me, but I do agree that reduction is probably in order since she has come into compliance. It's amazing to me that an owner would not know that she had to do this through the process.
I agree with that too. I think she has some obligation too, but I don't like that.
So your motion is,
I'd rather do that.
your motion is reduce the fine to $500?
Reduce it
Second.
to 5 or by 5?
2,500.
To 500, from
2,500.
3,000.
$3,550 to $500.
Correct.
Right.
I second that.
Okay.
If it's paid immediately. I'd like to ask that.
I don't know if we can do that. I don't think.
Do what? What'd you say?
We don't take master.
Call the question. Tom.
Okay, yeah.
Call the question.
Oh, okay. No further discussion? All those in favor of reducing the fine then from 3550 to 500. Aye.
Aye.
Any opposed?
Aye.
Okay, so I don't vote. 1, 2, 3, 4 to 1. It passed. The fine has been reduced to $500.
Thank you. I think that's fair. Thank you so much.
Okay, we're gonna take a break and then we're gonna come back to Mr. Patterson's case.
I'm going to come back, have your red hats on.
Well, no, yeah. You
There's
know-
another case?
You know the next case? No, but get ready. Yeah.
Oh, this is this one here.
You guys are good.
Got the Flomax going on.
I'm going to detective headquarters.
I'm gonna wait till they get out of there before I go in there.
He don't flow. I would want to take
I
care
would
of
have
me.
bought Santa Claus after all of it.
Hey, I'd want y'all to take care of me if I left here. And I may
You know about the saying is you can't fix stupid?
Yeah.
That's what we're doing.
Yeah, I know. Well, she's lying, but she's lying about it, because she had the thing. If she got it fixed, that's the main thing. That's what I'm after.
Get up here and you and I start playing bumper chairs.
Where the two of them, where that electric cart thing is.
You know what? She got the same figure. You know something?
How many more
Bill,
of these we got?
Bill, where is that Dixie cart, Dixie electric cart? That new building?
We just got one, oh, excuse me. We just got one more of these.
I'll
Get
pass
it done,
it.
get her done.
I was trying to get this bill before he left, but I'll call him
How
tomorrow.
much is this next round?
Yeah,
Wait,
I ain't fooling the next one. He got mad with me on that.
Let's go talk to Heather.
He ain't mad.
I'll call him tomorrow. I'll call him
Yes.
tomorrow.
he wanted at least a thousand.
Yeah.
Hey, baby, is mother okay? Okay.
Hey, look,
Hey,
I don't-
Porter, Commissioner Porter, do you recognize the lady sitting in the black in the front row?
Who is that?
Lily Chamberlain?
Hey, how you doing?
Good. You don't know who I am, do you?
No. I'm fixing to find out.
I see you getting on now, isn't it? She had a way of doing it, man.
Yeah, I never could date anybody local, because once they took me home.
Oh,
They
we
saw
all
my
knew.
mother and they were like, oh, no, I won't date her.
I'm surprised he doesn't know her. How's he not know her?
Yeah, we said what going back.
Is he a commissioner too?
Yeah.
He was, yeah.
Phil did a photograph. You got one.
Oh, no. I put a big note to myself, note to self, when moving home and retired, do not run for office. In fact, I almost became superintendent, then I figured out how stupid the teachers in the school is, and I gave up. I tried to give them $8,000 2 months ago. They wouldn't even return the call. I've seen ignorance, but I gotta tell you, your school board here, you're sitting on the top of the heap.
Are you trying to give them cash or something?
Yeah, if you would just pass out skin cancer information, the American Dermatological Society will give you
we just got
$8,000
back
to build a shade anywhere you
It was
want.
up there during the snow. It was.
Elementary school, could be for a day, it doesn't matter, you get $8,000.
California.
They wouldn't even return the call.
My son and the brother both, so they're all.
And I called Russell
Right
directly.
in the middle. My brother lives in Oakland, and my son lives.
But I'm sure we're gonna get, more steps at the stadium and the football team loses.
Right in the coast.
On the next case,
I ain't gonna say a word.
He's gonna bump it.
We're gonna vote that we're all gonna give the woman $10.
Pay for it immediately.
We all pay $10, okay?
Oh, you're a mess, boy.
One more.
I won't open my mouth.
We certainly can reduce the deficit by forgiving everything.
Well, yeah, you don't have to clear it. for-
Let me ask you about the tax
No,
bill.
I'll write
The
down
tax
your
bill.
question and I'll pass it down to Susan Cheryl. Thank you, Jeff.
Well,
The only thing I can tell you is that I'm a pass-through.
you passed through.
Yeah, no, because Thomas and I
He's a good cook.
Are you gonna save money?
So we kind of pass
Who
it
the
down.
fuck?
Huh?
Who knows?
Oh, yeah.
I should have
Yeah,
brought y'all some
you get a bigger
eggnog
reduction than you
scratches.
had.
You
made
Right,
that?
and then
Oh,
I
you
lost all
pay-
my
you pay at the-
Yes, I think it
Of
ultimately
which
will
one,
go
the
up.
Patterson?
You
The
are.
only thing I have
Why?
is,
Well,
because
if
it
you-
I
predates
lost all
me,
my
is
deductions,
the
right? 'Cause
order of
they-
the original
Well, they
ones.
gave you the standard, they doubled the standard deduction, so now let me pay this itemized, right?
Doesn't have alcohol.
Your
Well, I
fault for
can
not
have
having
alcohol.
12 school-aged children.
I had to hide it.
See?
Yeah.
You don't know how to play the game.
I know. All the kids are gone, what have I
You need a
got? All I
young-
got is student loan for.
You need a young woman and 8
And
kids.
I use your
No, I don't.
That's the good.
I did that.
No, there's just a big difference in chocolate. Percentage of the chocolate.
Oh,
You go into that fresh market, and they got like 80%.
what is that?
I'm
Oh.
gonna make, hopefully this
For
weekend.
Mr. Patterson?
Cake.
Oh,
Fudge.
I love fruit cake.
Imagine fruit cake fudge.
I'm one of the only guys I know who eat.
Oh, I love.
I do. I eat fruit cake. Claxton. No, wait for them every
Okay.
year.
That's interesting.
We surely look impressive up
I'm just
here.
trying to find $300.
You bet. You know, when I joined the board, we were all well-dressed. When I joined the board, everybody wore a suit and tie.
I know we should.
No, I kind of like it. I purposely wore this. It's like,
You know,
see, I'm just a regular guy.
We dress like this because we're following your lead. You put on a
I know, and that's what I realized.
The
Yeah.
next meeting, as long as it's not in the summertime, let's all wear a suit.
No, then we look like the enemy, you know? This way we look like.
Let's wear tuxedos.
Yeah, right.
When I was running for office, the guy told me, Chuck told me this, he said, if you're gonna win this election, he said, you need to dress like a commissioner. I wore suit and tie every meeting I went to for 8 years.
I know you did. You were a snappy
And
dresser.
the rest of them started doing it too.
Yeah.
But,
Oh, before that they
didn't?
didn't?
Well, our attorneys dress up all the time.
Maybe we should get robes.
Oh, at least we
that'd
can
be
do
nice.
out of respect.
Maybe the county fronts
Robes,
were robes. Yeah.
Robes,
Oh, robes?
but not black ones. Maybe like
Yeah,
No, y'all
maroon.
dress
the
up.
county colors.
Oh.
All right, well, enough of this.
I dress different from most. I don't wear
What am I
suit
looking
and
at?
tie.
Oh, I know about this.
Yeah, my best friend.
I have previous knowledge.
I wore Leroy.
You would have remembered this one because it was a whole architectural thing. It was like the guy had a commons foundation for three beachfront structures, 300.
No, man.
Okay, and that we were
It's pretty
ordering.
cool. That's what it's
We couldn't
supposed to
take
be.
it down without
Costume and
We call it
damn,
manana man because it's
All right.
always one.
You know, I can't even keep his contact information because he's a judge.
Okay, Mr. Williams, you ready?
So just put
And
it
call it back to order and put the time on the record, please.
All right. We'll call the meeting to order again at 7:55 PM.
This final case for this evening, and I appreciate your patience for it. Thank you for your patience this evening. 10-275, the respondent is Howard Patterson. This case was brought before the Code Enforcement Board on August 19th, 2010. The respondent was found to be in violation of section 110402A building permits and 50003A building setbacks. This case is very old. I went back and researched this when Mr. Patterson came to us stating that he was in compliance on his property. Through the research that I did and an actual physical inspection at the site, I determined on December 12, 2017 that Mr. Patterson had indeed brought the property into compliance. So from the date of the board's order to December 12, 2017, Mr. Patterson has accrued a dollar amount of $668,300. I would like to submit into evidence before I introduce Mr. Patterson the final board order from the board in 2010, and also the affidavit of compliance, which I recently signed and had recorded at the clerk of courts on December 21st, which was actually earlier this morning. I have a second copy if that'll help you folks with it.
Can I ask you some questions?
Yes, sir.
Is this the case where Patterson's son came and told us that he had been given the property by his father and he couldn't afford to pay the fines that were already on the property?
I
I'm
think
not
that's
aware of
true.
that.
I think that's
Situation
true.
was, I can only tell you that there was nothing mentioned of that in the report that I read regarding this case.
Which Patterson are we talking about here?
Howard Patterson.
Yes.
The father?
Yes.
Yes,
All
sir.
right. What happened to the property being turned over to the son?
I'm not aware of it.
Is that the son?
That's the son. Are you the son that appeared before us?
Yes.
And asked for a reduction?
That was for a different location.
I didn't hear that.
It was for a different location, you stated.
Okay.
Wait, you need to swear him in.
Have you been sworn in?
Yes, yes, I got him sworn, yes, sir.
He'll need to state his name.
All right.
What I understand
All right,
is
we'll
just
talk
the
to you in a
initial
minute.
Investigation on this, it was 3 structures
Right.
that were connected on Scenic Golf Drive.
They're all connected.
Yes, the original complaint was brought on the property at 925 Scenic Golf Drive. I think since the board ruled, those 2 of the 3 properties have now been bought by someone else. They're no longer owned by the Patterson family. So I'm not aware of any changing of hands of any properties. I only looked through the case. From what I could determine from the case, Mr. Patterson was the property owner at the time, and so that is why I'm presenting this here. There has been compliance brought on the property, which I went out and did an inspection myself, based on the research that I did and then conversations with Mr. Patterson, as well as building officials for the county. So there is compliance, and Mr. Patterson asked to be presented here before the board, and so I'm presenting him here before the board for a request of introduction.
I have a question. When, do you have any idea when it was brought in compliance?
I do not.
Well, we'll ask him that, but I'm assuming that there's been a lien or that's on the deed, and that's one of the reasons he may be here to,
Yes,
because.
I think he may be better to address
Yeah,
that.
okay, all right.
than I can tell you that this, like many other cases, was presented to the board, but there was never a follow-up to whether the property was brought into compliance. So he would probably be better to address questions regarding it. Yes,
Before you do, when did you inspect the property?
it was on the 12th of December when I actually physically went to the site and
Of this
conducted
year?
an inspection. Yes,
Of
sir.
this year?
Yes, sir.
And part of what he had to come into compliance was he had to get a building permit. And he has that permit?
I do not believe that he has gotten the building permit. I know that that was part of the initial thing. I'm not sure. I attempted to talk to the building official regarding that and did not receive information one way or the other.
So at this point, we only know that he's in compliance with
Yes,
50003.
physically, the setbacks
Yeah.
issue has been resolved.
But we don't know about the building permit.
I do not know whether he's obtained a permit for that. There was some conflicting information regarding whether it was done or not in the report. So I'm leaving it up to you gentlemen to determine what you would see fit on this particular case.
Well, maybe
How are we gonna do that if you don't give us enough information to know what processes took place? Has it gone, did it go back through planning? Did it go to anybody to bring, how do we know even what had to be brought into compliance other than the fact that the 3 structures were all hooked together at one point?
Correct. I can't answer that.
Somebody placed the lien.
I don't know how you ask us to make a decision based on not having any information. I think you need to take this back and you gotta come up and tell us what exactly happened from the point that somebody said you're not in compliance to how they got back into compliance and how long that took.
This should be our discussion.
You know, when did you say it went out of compliance? 2010?
Yes, sir.
2010. So we're talking almost 7.5 years or so? And you're coming back and saying everything's okay, reduce the fine?
Well, look, you should be talking to us because he wasn't here, okay?
Well, yeah, but he's still the boss.
Well, yes, he is, yeah.
It has nothing, you know, if nothing else, Bill, you should have gotten somebody's files when you're taking this job, right? You should have. I didn't ask you if you did, I just said you should have. So the point, what I'm saying is, I don't think you have enough information to tell me and maybe the other members of the board what exactly took place from the time that he was brought into violation and the time he got out of violation? How did he do it? What did he do? You know, what happened to the house that we already forgave? Where did that go?
That's a very good question, sir. These are questions that I cannot answer. However, what I can tell you is that there was something done to this particular property regarding a violation of setbacks. I attempted to get information on whether there was a building permit obtained and was not able to get that information.
Yeah, but you're coming to us with one property, right? And there were 3 properties involved in this thing, according to my recollection. All 3 of them were connected by a decking of some sort out in the back, right? And I think they actually could run in between the houses from inside, if I remember right. But the point is, I don't know what's going on here. I mean, you just walk back in and say, forgive me $285,000 because it came back into compliance. I don't have enough information.
Yeah,
And I understand that, and my request was that there is some compliance done on this. If the board chooses not to reduce the fine, that's the board's decision.
Well, I don't have any objection to hearing a case for reducing the fine, but I'd sure like to know what the hell went on first.
Let me ask you something.
Yes, sir.
If I didn't mean to interrupt there, but what, was any record of what happened after 2010 as to, did anybody follow up as far as the county?
There
as
is
far
no
as making,
record from the date the board made the order.
I mean, did anybody, how come it took so, why was nothing done within 7 years?
I can't answer that, sir. I don't know. I do know that
I
looking
understand
back
that.
to the report, there is no documentation from the day this case was brought to the code board and the violator was found to be in violation. There is no documentation.
How did the lien get placed on the property?
It's automatic. Keep in mind, it's up to the individual to let the code officers know that they're in compliance. It's not the code officer's responsibility.
I'd like to know what happened from the time they separated the one house that was deeded over to one son, who deeded it over to the other son, who came in here and said he couldn't afford to pay the fine. And we gave him some forgiveness, probably a lot, on that. So I think there was 3 houses involved in this, my memory tells me. Huh? So at some point, way back when, the sons separated one house and came to some kind of a conclusion, and he came in here and got forgiveness. Now we got 2 houses left, and all of a sudden, 7 years later, they come into compliance?
I was not aware that there was ever any compliance on the other 2 properties or anyone came back.
Help has arrived. Help has arrived.
Mac, you were here for this, so, yeah.
I can't hear you, Bill.
Here during this time, some coming to his rescue. 2 of those houses went into foreclosure. That's how the lien got resolved on the other 2 houses. It's not incumbent upon the code staff to go out and follow up to see if these violations have been corrected. It's incumbent upon the violator to notify us when he's come into compliance, to request an inspection to come out and look. He never did that until now. We're not here to advocate for a reduction in this particular fine. We're here to report the facts as we have them, and we don't have a lot of facts in this particular case. It's up to this board to decide whether or not to approve a fine reduction or not. We're not up here asking for one. We're merely bringing the case to you at the request of this particular violator. With the information that we have, and I apologize that we don't have everything that you'd like to know. There's a lot we'd like to know also, but we don't have that information.
It was his responsibility to bring it
It
back.
is his responsibility to come back here and ask for a fine reduction.
And is he here tonight?
It is not ours.
He's here.
Why
And
don't
he
we
is
hear
here,
him?
and I think he's prepared to speak,
Well,
but
then
I
let's
just
hear
want to be
from him.
clear.
Yeah, let's
This
hear
is
from
not our responsibility, and this is not our request.
So, I mean, he could just sit on this indefinitely.
Forever.
Why don't we listen to him, okay?
Let's do.
All right.
But he doesn't have to come here. He didn't have to come here.
No, he could sit here and let his
Unless
fines
the county
accrue.
chooses to
Yeah.
foreclose on the lien.
Transfer the property, he's all right, right?
Yeah, well, I wouldn't want a lien of $668,000 against me. Okay, Mr. Patterson. And Mr. Patterson, were you sworn in at the beginning of this meeting?
Yes, sir, I was.
All right. Would you state your name, please, for the record?
Howard M. Patterson.
Okay.
Jr., and that's my son, Mark.
Okay.
And I think that y'all, he came before you before.
Okay, look, the purpose of this hearing is to reduce the fine, right? It's not to argue the facts of the case. It's just to talk about why you think we should lower the fine.
The reason that I think that you should lower the fine is that my contention is there was never a violation in the beginning. And that
Well, let me stop you there, though. We found the violation to exist.
yes, sir, yes, you did, and we appealed that fine.
But we were successful, right? The county found the
It
violation?
never came back to you, it only came back to Gary Demers.
Came out to where, sir?
Gary Demers.
Who
Gary
is-
Demers, who brought the charge, is a person that we went all the way to the Florida Supreme Court, and it went back to Gary Demers, and Gary Demers determined not to bring it back to you.
Gary Demers being the code enforcement officer at that
The
time.
code enforcement officer, it did not come back to you, it came back to him personally. So, so in the
Wait a
meantime.
minute, it came to him personally?
That's an understanding that we have from the attorney that was just here. It came back to him, we met with the county attorney, my attorney, and my attorney, the county attorney, Lynn, whatever.
Hoshihara.
Well, I can't pronounce your last name.
I can.
We
Hoshihara.
we met with her. Another, my attorney met with Gary and that, and then this was to be we were to resolve this thing. This is at the very onset of this, and that at that point in time, that the way the code reads is that the exact reading of the code is that walkways, patios, porches, and decks are subject to setbacks. This was none of those things. This was a suspended slab. Now, Gary held that because the properties touched, that meant that they were in violation. That is not what the county attorney said. The county attorney said she disagreed. My attorney did cross collateralizations or between the three structures. Lynn said that was it, and Gary said that was his decision and not hers. Now, we asked that be brought back before y'all, and he didn't do it. So, in the meantime, we had no place to go. In other words, I can't walk in this door and say, I want to be heard from you. That came through Gary. All right, now Gary did not bring that before y'all. In the meantime, of course, we lost everything. We lost the two houses. Those were foreclosed years ago. Now, when those houses were foreclosed, the liens vanished from those properties. And now, in the meantime, that he goes before the county commissioners and says that that if he took out the top layer, there's two layers that support the structure, and that I changed the engineers to this thing, and a new engineer signed it off, and that the permit, these houses were CO'd, signed off by the planning department, which y'all are under the planning department, and the building department. We were given COs. This was a year after the fact that Gary comes to my door and says, you and I need to talk privately. And that the private conversation wasn't satisfactory with me. So that we elected to come to see this board. In fact, you were on that board. Yep. And at that board did not even speak to the issue at hand, which was that the buildings were attached structurally only. They were none of the parts that applied to the code at all. Now,
Wait a minute, you're confusing me, okay? You're saying that you were the officer Gary Demers came and said you're out of violation, and then you just
he said I was in violation.
You were in violation, and then you just said that there was a letter there that said you were out of violation.
Well, no, this is the code that says we're not in violation. In other words, what Gary said, and he told this board, that we're in violation. And that if you read the code does not say that. It does not say that at all.
But the
He
board
was
found
wrong
you
on
to
that.
be in violation.
Say again,
The
sorry.
board found you to be in violation.
You did find us in violation, and we appealed that. The appeal did not come back to you. The appeal went to Gary and our lawyer and the county attorney. The county attorney said that the situation that we're in, we had handled by cross collateral, cross easements.
And what was the date of that? What was the date that letter?
That's been 6 years ago, 5 years ago. And then Gary said that it's not your decision to the county attorney, and he says it's my decision. And so we're trapped.
And he said, it's my decision, and I find you
And
still
she will come
out of
and testify
compliance.
to that.
And he found you still out of compliance.
He said that he would decide whether we were in compliance.
And how did he decide?
He refused to respond other than, I don't want to go where he wants to went.
What did the appeal say?
Well, the appeal said we're not in violation. It's not a violation.
Well,
I mean,
you
it's very
appealed it.
clear. I mean, the code is very clear on that. We're none of the things, the fact that a building touches does not make it a violation.
Well, to whom did you appeal it?
To the Florida State Supreme Court, and they sent it back to Gary.
Well, then there's a record of that, right? If the
That's
Supreme
correct.
Court heard it, somewhere there's a record of
Supreme
that.
Court says that the decision that had to be, this is a quasi court. The decision is yours. Y'all make the factual, y'all determine, y'all are the only people that can determine the facts.
And we did that.
We never got, it never came back to the appeal. Gary would not let the appeal come back to this court.
Well, in the absence of the appeal, then our decision is final.
I had a right to an appeal.
Yeah, but
I never got an appeal.
Right, so.
But that was not your decision, that was Gary's. Gary is not your court, it's not the court. You're the court.
Well, look, we're the court within our jurisdiction, but we can't decide about appeals. That's beyond us.
You are the only people that we can appeal to.
We're missing dates.
We don't
sometime.
appeal
We
it.
don't have-
The state Supreme Court said that it was to be back and be visited, that y'all were the appeal of this court. Y'all the only people that could appeal.
So they didn't decide one way or the other?
Say again?
They didn't decide one way or the other?
Oh, no, it's your decision, not
the
theirs.
state's.
The Florida Supreme Court said that it was to be heard by y'all.
No, I think what he.
The appeal was to be heard by y'all, and it has not been heard.
Wait, could I interrupt you for just a second?
Yes, sir.
I think what he's saying that they said it didn't need to be appealed, I think.
That they didn't have the authority.
The Florida Supreme
Right.
Court turned down your appeal, is that
So there is no
They
case.
didn't, they said that they couldn't see.
They didn't.
They didn't have the
That's the
authority,
same
only
thing.
you had the authority to hear the appeal.
Right.
That's this panel.
Right.
And then Gary would not allow that to happen.
I don't understand what he says.
Okay.
I mean, I spent $80,000 having my attorney go down to see the county attorney. A county attorney said, now, we don't see that there's a violation. She said that the cross easements resolve the issue. And Gary said that that's my decision, that it's not his decision, it's your decision.
Which attorney is he talking about? What's the name?
No.
Previous is the county.
No, his attorney, who is that?
Who was your attorney at that?
You got, Will Dunaway.
Okay.
So that Will met with Lynn and Gary and myself, and that Lynn said that she was satisfied that the cross collaterals,
Well, what about?
it is resolved it.
All right, great.
And then Gary said that wasn't her decision, it was his decision. It was not his decision.
Let me ask
Your
another.
decision.
Let me ask another. Do you have a building permit?
We had a CO, we have a CO, we have COs on all three buildings.
Yeah, but
Now,
do you
we
have
don't
a
own
building
them.
permit?
Say again?
Do you have an approved building permit?
Yes, yes, all the buildings, this is a year after the fact.
Yeah, he'd have to have.
And you've got a CO there.
We have COs, we have, in fact, y'all's department signed off on this.
Well, it's not my department.
Well, the planning department, y'all work under the planning department. In other words, y'all are an arm of the planning department. They signed off on, this is a year after the project is completed.
What's the date of the CO?
09,
No, the specific date.
10th, I think. 6/10/09, and the complaint was brought over a year later by Gary.
Which complaint? The original complaint?
The original complaint was brought by Gary.
A year after this?
Say again?
A year after 6/10/09?
A year after it was completed.
Okay.
And Gary comes to my door and says,
Because
you're not in compliance. Now, Gary was the inspector, by the way.
Okay.
All right, Mac, what can you add here?
Sir, Matt Carper for the planning director. Mr. Demers was the planning director at the time. He was never a code enforcement officer.
Okay.
He was the planning director at the time this case became available. The encroachments into the setbacks occurred after the county had CO'd the 3 buildings. They were connected by walkways. And it was operated as a bed and breakfast for some period of time, as one building. It's not in a commercial land use category. It could not be a bed and breakfast. It's in a residential land use category. It was permitted as 3 individual homes. They were connected together, and that was the violation. And Mr. Demers determined that the violation had not been corrected and was a violation. And it came to this board, and this board agreed, and it entered an order. Subsequent to that, 2 of the homes were foreclosed on, and that's where the liens went.
Right.
Now, when these buildings were actually disconnected, we don't know. We just know that they have been now, because somebody else owns the other 2 buildings.
Mac, they were connected after he got the CO,
Yes, sir.
right? Yeah, I remember now. What they joined the buildings together to get between them after it was without a permit.
After the county had CO'd the original building permits for the 3 individual single-family homes.
When the Sons came in to request a reduction in the fine on that 3rd building, the buildings had already been disconnected at that
Right.
point. Do you recall?
And then he didn't build the building. He actually didn't own the building.
When
But
do
his
you,
name got put on.
Mr.
on the
Patterson,
lien.
when do you think the buildings were disconnected?
They've been disconnected for about 2.5 or 3 years.
Okay.
Now, the only reason let me tell you, the only reason those buildings were connected, these buildings were not
No,
patios.
we're not going to go through
Well,
this.
now, the
We're not going to,
building.
we're not going to go through this again. We're not going to hear the particulars of the case, okay? We're not going to do that again. We made that decision.
Now, the letter from the engineer, we changed engineers. Now, the engineer that finally sealed the building said that those buildings weren't connected, that they would not stand.
Mr. Patterson, look, in spite of your best efforts, we found that the buildings needed to be disconnected, okay?
Well, they have been now.
Great, that's all we need to
And
consider.
what we're doing is we're trying to get a reduction in the fine because we don't have.
Exactly, and that's what we need to.
That's that maybe, I know we were wrong in the beginning, wrongs happened. That was not right what happened, but it's over now. They were disconnected and they're structurally sound now, and that, I don't think we ever created a violation. I don't think we violated anything. We came back in with an after the fact permit to make those structural pieces, connections between the buildings. My engineer says they weren't going to stand. Now, I'm not going to put anybody's life in jeopardy because a building collapses.
Well, Mr. Patterson, what do you think is the appropriate action that we should take?
Well, I know that I'm destitute now.
Well, you
No,
admit
'cause
this.
I don't have any money.
Yeah,
I live on Social Security now.
you still own the building though, right?
Well, it's just a debt on a building that it'll be foreclosed on and the lien will go away again. And the county won't collect any money once I'm foreclosed on. The other two buildings were foreclosed on, the county got no money.
Well, if you think that the third building's gonna be foreclosed upon, why are you concerned at all?
Well, we are trying desperately to save the last building that we own.
Okay, well, until you transfer ownership of the building, you don't have to pay this lien.
Oh, I know that, I'm 77.
Yeah.
All right, now, what happened was, my son came before this court. Somehow he got put on that lien. He's trying to make a living. And that his name gets on a lien on a building that he didn't build, he didn't own, and there was no violations on it. And y'all fined him $5,000 so he could sell a piece of property to make a living. Now, how that happened, I don't understand how that could even happen. He never even owned the building.
Yes, he did. The story he told us was that his brother had signed that building over to him.
That was only when my brother had gone broke. My brother Mark loaned him money and he signed the deed over to him. Now he didn't do anything to justify a fine.
Well, of course he did. He took over the ownership.
Okay, well, that's okay. You're absolutely right. He took over the ownership.
What's the
And
value?
he got a
of the property?
$5,000
Let's go
fine.
back to your one remaining house.
What's the value of that one remaining house?
What's the money?
It's probably 400. The house right next to us sold for 300, and we think ours is worth 450, and we owe 680.
You owe 600. 680 is the fine, right? Or is that the
No,
mortgage?
that's how much we owe the bank.
Property's a lot.
The fine's as much as the house. Now,
The mortgage.
yeah, the mortgage.
The county just paid, if my memory serves me right, over $1 million for that house.
Absolutely right. In the house beside us, the guy that bought that house paid $300,000.
Yeah, when? 40 years ago.
3 years ago.
917.
917.
He paid $200,000 for that house. That's the house that allegedly that I had possession of.
You're saying that the house that the county just paid over $1 million.
He bought it out of foreclosure.
Pardon?
He bought it out of foreclosure.
Yeah, I can't believe it either. I mean, that's the only reason why we're willing to hang in here and kind of keep paying notes. Now, I've borrowed money from every family, friend, and buddy that I own.
Yeah, but what you told me is that your next door neighbor just sold his house for over $1 million and yours is worth
He sold it to the county.
He sold the county.
He sold it to the county. He didn't sell it to a private person. He sold it to a county. Which
I understand that.
Yeah.
Well,
The point is, assuming that the county paid a fair price for that, they spent $1 million. And you're saying that you have a house next door that's only worth $300,000?
Well, he bought two of them. He bought 917, 925. He bought two homes, one for $200,000 and the other one maybe for $300,000 or $400,000. We don't know.
But he bought them out of foreclosure, so he bought them.
And then the other house sold through the county.
What it's worth today, what it's worth.
Well, why does that matter?
And he had to sell with
$1 million, that's why.
Yeah, which he's gonna pay us $665,000.
Well, there you go.
Oh, that's the place? Well, that's pretty accurate. What do you say, 4?
No, the bottom number's what you need to look at, 1.122. The just market value according to property appraisal is 1.122.
That's what the county says?
That's what-
2 million,
Yeah. The
The county thinks you're sitting on a gold mine.
building value.
The county has it valued.
Well, I sure lost a lot of money when I
At
was
$1.2 million.
foreclosed on other houses.
All right.
Can you make it?
Yeah.
Can you make it something that we can survive?
All right, I get the, yeah, what do you make, tell me.
I was hoping Mark's 5,000 was gonna do it, but apparently that's not it.
It might be
Can it be
Has he
anywhere
paid
between
that?
$5,000 and $15,000?
Okay.
I mean, what happens is I've got a brother that owes me money. I've got a sister that loves me. I don't have any money. but we'd like to keep the house.
Okay. Thank you, Mr. Patterson. We're going to close the public part, and we're going to discuss it.
Thanks so
Gentlemen.
much, and I appreciate it.
Yeah.
But there was more to the story, but I know y'all's time's
It appears
important.
that there was a county employee that did something wrong. When it got some kind of appeal back and didn't communicate it to somebody.
I remembered incorrectly. Gary Demers was the planning director, same job Max got, okay?
Yeah.
And he had the right to make that decision. And he made the decision, and we accepted his decision.
And we don't really know the
And
story.
we don't want to know the story. We just want to know whether we're going to reduce the fine. Because we found him in violation, okay? And he never got out of violation until.
Now, let me tell you. what
No,
we
no,
did-
no, you're done, you're done. Until 2.5 years ago.
The only violation was the decks were connected. We're not talking about setbacks.
There are two things that were in violation. The buildings were connected, and he said that they were disconnected 2.5, 3 years ago, and he didn't have a building permit, and you guys.
No, I didn't disconnect.
No.
The other guy
Running a
disconnected.
hotel and residential.
Okay, but that's all water over the dam.
What was the fine
Okay.
imposed for?
For
The connection or
the
the-
connection and the lack of a building permit.
Yeah, he modified the three structures, connecting them all without a permit.
After he had the
Oh, we put
CO,
them
he
together.
modified them, put them together. That's what Mac told us, okay?
Okay.
Now,
So,
now,
he no, Mr. Patterson, you're done.
can I say one other thing?
Patterson.
We
Wait,
came
wait.
in with plans, and that Gary would not approve the plan.
Mr. Patterson,
And then
you-
the guy that got the bills,
Do
he
yourself,
did the plan.
do yourself a favor, sit down.
I think we should err on the low side here. I think, I heard the $5,000 number, I think that's way too high. For what I've heard here, there's some something going on here, and there was some
Yeah, but
appeal to
it's
some court that somehow didn't
Without trying to sound better than thou, there's some disparities on both
And
sides.
we dropped it, we never followed up.
Yeah.
I want to hear about the Supreme Court.
I do too.
Who was representing?
Well, 600,000 is ridiculous.
Wait. It's impossible for her to take notes, and I can't understand. Yes.
Mr. Dunn, he was represented by counsel during the appeal. Counsel would have notified, code enforcement would have also notified him. It was his own attorney's duty to inform him of what he needed to do after the appeal.
So
He
can
needed
sue
to
his
pay,
attorney.
he needed to bring
So he
himself
had an
into
attorney at
compliance.
that time.
Yeah, so he knew he had to come into compliance.
Sure.
And it took him 3 years to get into compliance, okay? He did that, and certainly deserves something for having made the effort, okay? Does he deserve $668,000?
7 years to come into, well, it was in 2010.
I'm still not sure that he has a building permit. Bill doesn't know whether he's got a building permit or not. The fact that he had a CO didn't count because the changes he made and needed to be undone were after the CO.
I know that, but he came into compliance, we know that, so that he had to. have
We
taken
don't
it.
know that he came into compliance. We haven't heard that he's got a building permit.
Whoa. He had a building permit because he got a CO. Let me listen.
Yeah, but the violation was after the CO.
Yeah,
It was after the CO.
right.
Then he
They didn't have a
has
permit.
removed,
The
my understanding is he had removed the problem that caused the problem in the first place.
What about the building permit? Why
There
are
was
they,
never
why
There
are
was
they,
never a building permit. He took out what he built,
Yeah.
and so he didn't need a building
There
permit,
was
so
a
he came
building
in
permit
compliance.
for the infraction. He got the CO, the certificate of occupancy, and then he added, without anybody knowing.
all right,
he joined the
I
building.
guess I need to shut up because the same thing applies to what I'm saying. Hey, it's water over the dam.
There's
The only
too
thing
much.
we're talking about now is
Is
the
the
fine
reduction.
reduction.
I say
How much it
zero.
gonna be?
I
Let's
think
go.
we cut it 50%.
I say zero.
Okay, I've got 335 and I got 0. Anybody else got an idea?
I say 20.
And he says 20. You're the auctioneer, not me.
20 off?
No, 20.
Well,
You
we
gotta
need
do
to,
15.
I don't like basing it on something like this and try,
No,
I don't understand,
Well, what do we
why.
base it on?
I'm trying to get to a point.
Okay.
You know, if we knew when he removed the issue of adding the decks, we knew when he took all that out.
He said 2.5 to 3 years ago.
Well, then basically from that point, he should have informed code board to inspect. And from that point to now, is what we're talking about, is that right?
Yeah, and look, just in round numbers, if you make this 700 grand and it's been 7 years and he's been in compliance for 3 years, then 4/7 of this, 400 grand, would be the fine if we charged him the full dollar value and gave him
$10.
and gave him credit for having not reported that he was in compliance.
Do we have any record of the fact that he was inspected by anybody when he came into compliance?
We have now. He just did.
They did on 2 days ago.
Yeah, he's in
2 weeks
compliance.
ago.
2 weeks ago.
We know 2
So-
weeks ago he was
Yeah.
in compliance.
So we don't want to talk about coming into compliance 3 years ago. We want to talk about coming into compliance.
Let's say
2 weeks ago.
$250 for the last 2 weeks. I'll agree to that.
No,
no.
no, you're looking at it backwards.
Well-
The 250 for the 2 weeks, he shouldn't have to pay.
Well, there was, all right, there was 4 days between the time he went to Bill and the time Bill got it, did the compliance thing. Bill just got the compliance thing done today.
Right, so, you know, give him 3 weeks credit, I don't care, that's meaningless compared to his
I'm not saying
665.
credit, I'm saying, but the time Bill found out about this from the first day, it was like December 8th. First time you ever heard of this case?
Oh, no, it's been
Well,
going
it's
on.
been a
long.
little longer than that. I've been trying to research it so
How-
that I would have more information.
Give us a
I don't think
ballpark.
he's missing something.
When did you first learn about this
You don't
case?
think?
I
It was
think he's missing.
Me too.
back in, it was early November, maybe late October, sometime in there. I don't
All right, let's say Halloween.
Yeah, but why do you care what he,
Give me the logic. I don't understand that
Because
logic.
yeah,
there was no follow-up on the part of the county.
there was no
It's
obligation.
not
There's
their
no
obligation.
obligation, I don't care. We take that up, we follow up now.
No,
No, we don't.
We follow up now.
No, we don't.
Yeah,
Not
we
until
do.
not till they,
On new cases, we follow up.
We,
And we should have followed up on
the
this one.
burden has always been on the violator to
Right.
notify the county.
just like,
We've since changed that because we see a lot of these cases where, we have large fines sitting out there that we would like something to be done, so we've started tracking cases throughout the
Now.
department.
That would be a real good idea.
Let's say,
All right, 20,
I'm gonna rescind mine.
okay. So far, the only.
0.
I've got 0 and I've got 668,000.
You want to what? Reduce the fine to 0?
Yeah.
I wouldn't be for that. because
Can't be zero.
All the work that's gone into the thing, for one thing, but he's agreed, he's receptive to 5 to 15. So, I mean, that's a fair fine there, somewhere between there.
Well, it certainly is given his financial situation as he presents it, it's a substantial part of what he's got.
Yeah,
Well,
well,
But it sure is a pittance when you look against the 668.
yeah.
well, if you go back and look at it,
Can we talk about assessing this fine at the time of sale so that we can sort of attach a lien on the sale of the property? Because we know that the property's worth $1 million or more.
Well, what if he doesn't sell it?
Yeah.
Well, eventually somebody's gonna sell it.
Well, I know, but
No, you can't
you
do
want to wait until his son.
that. Nah, you
well,
can't
on your
do that
logic,
still.
it'd be 90 days and that would be about $25,000.
Yeah.
I ain't going that high.
How do you figure this?
It's too high.
90 days.
90 days what?
Well, talking about going back to the November timeframe, October, Halloween,
He
whatever it
even
was.
said 5 and 15.
Oh, you mean when he found it, when Bill found it in compliance,
Mm.
it's been 90 days? Or
Well,
he,
no,
when he
when-
could have found it in compliance, it's
I
been
was just
90
taking his
days.
logic, trying to figure out a way to.
Yeah.
How's that 7,500?
Wait, we're going to listen to a legal opinion here.
Thank you, Chairman. I'm not offering any additional evidence or other information, but I just wanted
Would you put the mic down by your
Oh,
phone?
yes. Just hopefully it'll help y'all come to a decision. Whatever you all decide in regard to the fine amount is, of course, up to you. But I just wanted to let you know, the county, of course, as you know, would in theory be the beneficiary of any fine that is imposed. And the county does not object to a reduction of fine, even down as low as $5,000. But whatever you decide, I just wanted to let y'all know that.
Okay.
Well,
there
the
you
county
heard
wouldn't
it.
get any money anyway. They're not gonna get
Well,
any
no,
money
if you
anyway.
made it $5,000, I'll bet you
Can
paid.
anybody make a motion at this point?
No,
Not yet.
go ahead.
I say, can anybody?
Yeah, sure, go
I
for
make
it.
7,500, I think it's halfway.
I'll second 70.
All right,
Pay
I got
5,
7,500 and I got 668. I'm ready to vote
Who's
on
on second what?
One second.
Going once. Yeah, okay. I'm gonna, unless there's further discussion, I'm gonna call the question,
vote.
and that is $7,500 fine. All those in favor?
Anybody got a second on
Yeah.
it? Oh, okay.
All those in favor?
Aye.
Aye.
No.
Okay, so it passes 1, 2, 3, 4, 5, 5 to 1. You got fined $7,500, Mr. Patterson.
Hallelujah to it.
Yep,
Payable tonight.
okay.
Yeah, you gotta hurry up with that.
You got,
I make a motion.
how, do we have to
Hold on.
give him, wait, do we have to give him a time period in which that needs?
Now you need to do a motion for a time period in which it needs to be paid.
Okay.
Thank you.
How
Wait,
much time do
How
you
much
need?
time you need?
There's hope.
Christmas is.
No.
Mr. Patterson,
You
how
gonna
much
write the check
time,
now?
how much time?
Check down, I got to see my sister, my brother.
Well, I'll listen to
all my
him.
friends.
No, I'm not.
Guys,
Yeah.
you need to make a motion, you need to make the time frame.
How much time do you need?
Don't ask, just,
Don't,
Well, I need to, that's right, he can't.
Well, I just tell you what, I've done so damn many good things for them, they owe it to me.
Okay,
And I
30
can
days.
do
30 days.
it As soon as I can.
All right,
I get you by the end
I'll
of the week.
second.
yeah. All right, all those in favor of 30 days? Aye.
No.
All right.
Thank you, guys.
All right.
Hey, thank you so much.
All right. Okay. Is there anything else that we need to
It's
deal
good
with?
having you, I love you.
Somebody likes to see that. I think so. That's it, right? There are no further cases? There's no further,
I move we get time and a half.
Let's all start sending Santa
I
Claus
will take the
coming.
board's recommendation and I will bring you better information on further cases.
well, I give you extenuating circumstances since you weren't here, yeah. Okay, listen to a motion to
I'll
adjourn.
tell you, Bill, I don't understand.
And
why
a second?
I make a
there's no
motion to
file in
adjourn.
your
And I
office.
got it. This meeting is adjourned.
Are we all gonna sing Santa Claus coming to town?
I need, yeah,
Not you.